All right, the first bill up today will be Senator Gatti and Senate Bill 78. Before we get to that, we're going to have a few bills that are deferred until next week. I'm looking for my agenda here. Thank you. Senate Bill 395 dealing with the Law Institute. That will be temporarily deferred until next week due to the fiscal note that came out, and we agreed with all the parties involved. Out of fairness, we would hear the bill next week, so that bill will be heard next week. And then also Senate Bill 401 by Senator Gatti dealing with civil jury trial threshold will also be temporarily deferred at this time. All right. Senator Gatti, Senate Bill 78.
Thank you, Mr. Chairman, members of the committee. My name is Senator Ryan Gatti, and I'm from Bossier Parish. I represent Bossier, Claiborne, Webster, and Bienville. And Senate Bill 78 addresses an issue that has come up over the years with our medical malpractice cap. With broad strokes, I just want to give some background of the medical malpractice cap. In the 1970s, there was a movement across the United States to cap medical damages because we have surgery is a dangerous thing. The things hospitals do are dangerous items. So we came up with a system where the doctors were afraid that they would lose their personal assets if the claim was too high, and the court system really wanted to look at things in a different manner. So they cobbled together a compromise through a lot of hard work of lawyers and doctors and this legislative body. And they decided that it was very important to cap medical damages. What most people don't know in our state is that cap has not been changed since the 1970s, before most of us were born. So at that time, they said, you object to that, Senator Martini? Well, there's kids here today, so I did an average of the group, and those guys. No. Well, it depends on how you're going to vote before you recuse yourself. All right. So in the 1970s, they cobbled together this compromise that said, we agree ahead of time that no matter how catastrophic the injury is, that a family can only recover $500,000 plus medical bills. Well, as medical technology got better and better, we're finding that when people get hurt with severe brain injuries, they survive. And they survive for a long time. And so when we look at this special situation, what we find is that many people don't know that this bill, the Medical Malpractice Act, actually created two classes of people, and they treat them totally different. And the Supreme Court has said recently, that's okay. So you have these two classes of people. The first class is the person, let's just say they go to the doctor, and he doesn't ground the pad good for their surgery, so it burns a hole in their leg. Okay? And they did a little skin graft, and it's a horrible injury, it's painful, but it's worth less than $500,000. Okay? Well, they're fully compensated. Let's say they go through the panel process, they do all that they can, and someone determines this case is worth $125,000. Well, that's well under the cap, so they're fully compensated for their harms and losses. And you creep up more and more up to the cap, so if somebody gets a $490,000 verdict, they're fully compensated, 100%, whatever that injury is or that claim is. It's when you start to get over the cap that we start to see a great injustice. And one of the greatest injustices we see above the cap is we've had cases in Louisiana where a jury of their peers hears the case, and they feel sorry for the doctor for making the mistake. They feel sorry for the family for the long-time, lifetime injury, and the jury awards maybe $4 or $5 or $6 million for a brain-injured child or an adult. Well, in that situation, procedurally, looking back at the amendments to the Act, what has to happen if you're the judge, when the jury says, this is horrible, we want to give the family $3 million to cover their pain and suffering. And we want to give them unlimited medical, but we want to give them the pain and suffering that's equivalent with a fair trade value of the harms and losses they're suffering. What has to happen at that point is the judge thanks the jury, he lets them leave, and the family's still sitting there, the doctor's still sitting there, and the judge says, I have to order the damages of $3 million awarded by your peers. I have to reduce that to the capped amount of $500,000. That is the practical effect of the theory of medical malpractice reform. So once again, the courts have already said you can create two classes. That's completely fine. But what the Supreme Court recently said, and I was going to read the whole case into the record, but I'm just going to tell you some blurbs out of it to save time, is the Supreme Court said the legislature decided this. The legislature can do a constitutional balancing test. The legislature can balance the citizens' rights with the medical profession's rights. And they said since the balancing test happened, since it's a legislative act, it is not unconstitutional to have a cap. Well, the next logical step in that evolution is that we as legislators would look out into society and we would say, is this cap still enough? Is it? Is it something that we want to hang our hat on and call it justice now that medicine has advanced? Is it something that we want to go back to our constituents when they call us, after they hear about this bill and say, hey, I'm sorry, but we agreed way ahead of time in 1970 that your child's brain injury was only worth $500,000. And that's something that this bill directly deals with. So there's been a lot of scare tactics. There's been a lot of emails. In fact, some of the people that were coming to testify received letters reminding them they had a gag order on their settlement. And so they didn't make the drive. So what this bill does is it basically says this: based on the Supreme Court's recent finding that we as legislators get to dictate the level of safety in our community by the level of the cap. This says we're only going to carve out a specific low frequency, the most unjust of all of these injuries, which is someone under 18 who, because of medical negligence, suffers a moderate or severe brain injury. Not a mild brain injury, because as y'all know, mild brain injuries are defined as losing consciousness. This is not what this bill does. This bill directly only affects a diagnosis of moderate or severe brain injuries. And at this time, I think it's proper that I offer my amendment 1760. I'd ask the staff to pass that out, because I think now's the proper time to talk about how narrow the class of people who would be able to even partake in this bill. And while they're passing that out, I'll just explain it. I mean, we wanted this to be a very narrow exception that creates a third class of recovery under the Medical Malpractice Act. And based on what I've been told, there's only been 4 of these a year. That's what I've been told. And I know they'll testify today after filling out a red or a green card, and we can ask them if it's a higher frequency than that per year. But the yearly average I've been told is 4 catastrophic child brain injuries per year. So we're not talking about a huge class. So what we've done is we have inserted on page 2 that this only pertains to catastrophic brain injuries. Okay? And then we went to give a definition that is conducive to the legal definition of a brain injury, which means any moderate or severe traumatic brain injury. Now, there's 3 classes of brain injuries that are acknowledged by neuropsychologists in their writings, and there's three levels that are acknowledged by the courts: mild, moderate, and severe. Without getting into too much of those definitions, mild is they use the Glasgow-Coma scale. They could say you lost consciousness for 30 seconds, 15 minutes, and that would make you a candidate for a mild traumatic brain injury. That's not what this bill is about. This bill goes further to say it must be moderate or severe traumatic injury that causes a child to lose partial or total use of one limb become a paraplegic or a quadriplegic. So that is the orthopedic component of the neurological injury. So if a child has a basal ganglia injury from a hypoxic ischemic event, whether they're having rotator cuff surgery and were positioned wrong, or whether it's a birth injury, well, that child, and we're not talking about somebody that loses consciousness for 5 minutes. We're talking about someone who has lesions in the brain. It's an objective finding. You can put their MRI on the table in front of any neuropsychologist, and they will say, that's a lesion. That lesion is not something you walk around with and play baseball with. That lesion is the reason why they can't move the right arm. Okay? And so that so let's go back to the definition of the amendment on line 9. Catastrophic brain injury means any moderate or severe traumatic brain injury that causes a child to lose partial or total use of one limb or become a paraplegic, which is they can't use, two of their limbs, or a quadriplegic, meaning that their brain injury is so bad they have lost the function of all motor skills. They're basically wheelchair bound. And child means a fetus in utero, all the way up to somebody who hasn't had their, who's under the age of 18. And we all know that's defined by the courts as you haven't reached your 18th birthday yet. So if they're 18 years in one day, this doesn't apply to them. We make other similar age classes, for instance, first-degree murder. If you're under 12, or I think if you're over 65 and you're the victim of murder, the defendant is charged with first-degree murder just because of the age of the victim. So throughout our legislative history and our intent, we always protect children. Children are our destiny, they're our hope, they're our future, and they need to be protected because they're the most defenseless when it comes to this. So here's where the objection comes in. I don't think anybody agrees that if well, let's talk about the procedure first. Currently, the procedure under the law, now that we've got the class... Yes.
I don't want to interrupt you, Senator Gatti, but would you like to go ahead and adopt the amendments, and then we can...
Proper at this time, yes, sir.
Are there any objection to the amendments? No objection, the amendments are adopted.
Thank you. So now we have the class of people properly defined that can recover. Now I want to tell you a little bit about medical malpractice procedure before we talk about the narrow gate these people have to go through procedurally to even recover the excess cap. What you hear today is deferred maintenance. We talked about that in this room yesterday. It's the drilling and the fixing of broken down stuff. So bear with us. That's the sound of progress. So let's talk about the procedure under the law currently. Just with broad strokes, I don't want to get into the weeds on this. If someone is suspicious that the injury they have comes from medical malpractice, they have to file a letter with the patient's compensation fund. A board process is put in place where a panel of 3 doctors that are chosen by each party, they look at the medical records and they talk with each other and they get to vote. Panels can vote 1 to 2 for the patient, 1 to 2 for the doctor, or unanimous that the doctor was okay, or unanimous that the patient has a claim and the doctor fell below the standard of care. So that panel of doctors is a very important step in the process. So,
They're in the process of getting that noise to stop. I apologize.
Okay. I suspect that'll be just one of the few interruptions to my my goal here today. So we talk about the procedure. You have to go before the panel, and if you get a unanimous panel against the patient or unanimous panel for the doctor, then that kind of stops the process. A lot of times the lawyers will tell the patient, look, you've had 3 doctors already say this isn't malpractice, you just need to dismiss your case. However, there are situations, very rare, where the panel rules in favor of the plaintiff. Then the plaintiff has the right to file a lawsuit.
Do you want to pause for a second while they
Sure.
get that taken care of? It's important, and we need to make sure we hear everything.
Sure. I have some jokes I can tell while we're waiting on that.
That'd be good.
All right. A lot of people ask why we run for the Senate. They say, why don't you run for the House? And I told my oldest daughter, who's 16, I said, look, the Senate is like Starbucks. We walk in there, we drink our coffee, we look at our laptop, we may or may not have to talk to people. It's really nice. I said, the house is like when you go with your mama to Walmart on Black Friday. I said, your buddy will run you over for $50. I said, so that is why Daddy ran for the Senate and not the House. But I love, if any House members are listening, that was a joke. No allegory or metaphors.
I think we're good now. It sounds
Right.
like it's stopped.
Right. So let's talk about that procedure. First of all, the patient has to know that something has happened. They have to follow the procedure of the Medical Malpractice Act. One of the biggest points in that procedure is that you go through the panel stage, which is a very great procedure. It's awesome because you get 3 doctors to take a fresh look at the medical records, and they say, either this was above the standard of care, it was at the standard of care, or it was below the standard of care. And then they have to say whether or not the injury was caused by the doctor. And so they go through that process, and they put a lot of time and effort into it, and it's a good process. And then the patient has a right, no matter how the panel turns out, to file suit, go to trial, and go before a jury of their peers and have their case heard. That was supposed to be a very efficient process that would take less time. It actually takes just as much time as a regular lawsuit in most cases to go through the process. So let's talk about what this bill does. So we've talked about the class of people that would qualify, okay? Those are children under the age of 18, in utero to 18 years old, who have suffered a catastrophic brain injury. And catastrophic brain injury is moderate to severe with the loss of partial use of one limb, paraplegia, quadriplegia. So that person is sitting there. This is what they have to do next. The panel of doctors has to be unanimous for the patient. Now that may seem insignificant to the public, but what I have heard from talking to folks that do a lot of this work is that is a rarity. It's a rarity because the doctor who may or may not have committed the malpractice gets to select one of the members of the panel himself. And so he's selecting somebody for the panel. And that means that person even said, man, this was not just below the standard, but also caused the damage. So what this bill says is you either have to have a unanimous panel, or if it goes to jury trial, which 90% or more of these trials never see the jury because it's too emotional for the family, quite honestly. Most lawyers will not drag their clients through a trial like this because it opens up wounds that have had stitches, and they've opened up and the stitches break and it gets infected, and it's an emotional wound. And 2 or 3, 4 years down the road, most people just say, I'm emotionally bankrupt. Take whatever offers there. Now you have some rare people that want to be advocates who go to trial and take cases to the state Supreme Court. So here's what has to happen. You either got to get a unanimous jury, a unanimous panel, or a unanimous jury. Now I don't want there to be any confusion. It's one or the other. Okay? But I can guarantee you if somebody gets a 3-0 panel against them as a patient, they're not going to take that to jury trial most times. You see? So we have a narrow definition that we have to balance based on what the Supreme Court has told us. A class of people, do we think our children who suffer quadriplegia, paraplegia, loss of a use of a limb from a unanimous panel, in a unanimous panel situation, do we think they deserve more than $500,000? That's what the decision you have to make today. You have to agree ahead of time the value of a child's brain. Now, National Geographic, I love their just so the camera can see it. It's called Your Brain. And they dedicate an entire issue into what your brain does. Now, this is a lot easier to read than all the neurology journals I've read and the neurosurgery books, and even my high school biology book could have put some of these pictures in there and made it more interesting. But they laid out everything your brain does. I mean, when you ask a child, what does your brain do? Some kids will say it helps me smell, it helps me see, it helps me remember grandma, it helps me remember things. Other kids will say, well, that's how I can throw a baseball. Dad says I have good hand-eye coordination, and all those circuits go through my brain. But a lot of people, when you get older and you start to be around people whose brain is failing, you start to realize how precious the moments were that you had an intact, functional brain. So the brain injury is one of the most devastating catastrophic injuries because typically the person doesn't know they have the brain injury. They don't know it. They don't know they have the brain injury. The brain limits so many activities that we do that we take for granted. Walking, talking, throwing a baseball, playing softball, running, eating, calling out senators' names when they're not paying attention, Senator Milkovich. You know what I'm talking about? There's things that our brain does, and when you really get into studying the brain like I have, because, my daughter is a spastic quadriplegic from a situation that was a unanimous panel, you start to say, is there any help out there? Is there any stem cell research? I've talked with doctors from all over the country, and I said, I'll be there tomorrow with my child. And they say, Ryan, we've looked at the MRI. Even if we severed her spine at her neck like we do with severe cases, it's in her brain. It's not in her bones. Her bones are shattering around her hip because of her seizures. So even if we severed her spine, which is the most outlandish rare case surgery, she would receive no benefit from that because her pain is in her brain. Now sit back and think about that just for a second. No hope. We're not talking about people that say, I used to could move my arm like this and now I can't. We're not talking about those kind of medical malpractice cases. And he just moved his arm. He's not telling the truth. We're talking about objective, catastrophic injuries that currently under the cap is a complete injustice. So we have Senate Bill 78. It doesn't change the process. What it says is if you have a child under the age of 18 who has been severely, catastrophically injured with a brain injury, and guys, I'm going to tell you this just to be straightforward, this doesn't include spine injuries, this doesn't include decubitus ulcers, this doesn't include mama went to the hospital, told them she was allergic to morphine, and during surgery they gave her morphine and she stopped breathing and she's got a hypoxic ischemic event and she's got a brain injury. Doesn't cover those. All right? Because what we see in older people is if they suffer a brain injury because their brain is already myelinated and there's already connections and the corpus callosum is intact, the midline of the brain, that we can send those folks to a brain rehab center and they can relearn a lot because they can make new connections. But when it's a child, there's no connections there. They haven't reached those milestones yet where their brain has myelinated. So there's nothing you can do except love them, care for them, and consider them the blessing they are. You see? So what Senate Bill 78 does, it says basically two things. It changes the process for a small group of people, and then it raises the cap from $500,000 to $5 million. You may say, well, that's a drastic increase. How did you come up with that number? Times 10. That's all I did. I just said, this is 10 times worse. 10 times worse, and it's a rare thing. Now, you're going to hear a lot of arguments about this is going to cost people more money, and then health care costs are going to shoot through the roof. But you know what we find in states without a cap? It doesn't really make a big difference. In states without caps, doctors sometimes can't get, they want to go practice in a state without a cap, and they can't. And then they say, well, why can't I practice in your state? So we don't have a cap. Everything you do could affect the assets of our hospital. Think about that. Now, in our state, we have a $500,000 cap. So there's a lot of guys that compete with our excellent doctors who are board certified. Or like this old cardiologist that I know, he's not board certified, but if anything happens to anybody in Shreveport Bossier, they want to be on his table. All right, God has just blessed him with the ability to open your chest and fix it and sew you back up, and you're out playing golf in 2 weeks. When you have a state that has a cap, we have unintended consequences of marginal practitioners competing with the best of the best doctors we have. Now, I don't say that to offend any doctors at all. What I'm saying is we have the best of the best in Louisiana. They could practice in a state without a cap. They practice here because they love Louisiana. I've talked to many of them about this bill who say we like this bill. Because what they say is I'm tired of competing in my market with people who are marginal practitioners. in fixing their mistakes. Now, they can't be here today because, I mean, that would be a really tough thing for them to say in front of the people that are sitting behind me. So, once again, just to clarify the record, this is for a small group of people who have the worst kind of injury, and they have to meet a procedural hurdle that most cases will never meet. So I just ask for consideration from this committee, and I would appreciate any questions.
There is a question from Senator Martini first.
Thank you, Mr. Chairman. And I wasn't here in 1970 when they enacted the cap, but I was born. My question is, and I thought a technical amendment on your brain injury catastrophic brain injury definition. Obviously, it has to be a severe or moderate or severe traumatic injury to the brain. It would seem like under this definition, it would seem like any injury that caused partial use of a limb. I mean, I hurt myself skiing, and I have 3 numb fingers on my left hand. I guess that's a partial. I don't know if that cleans that up or not. But that's not my. The big problem that we get, that I've gotten feedback or from doctors claiming that the malpractice insurance premiums are going to go sky high, and while you appear to be limiting this to a very small segment of claims, it would appear to me that there's a vast number of physicians who could possibly inflict this type of injury that would be subject to, and you pick 10 times the cap. I don't know what the does that mean that the malpractice premium is going to go up 10 times? Because obviously, in 1970, when they were considering this, I would think one of the considerations was that doctors were not going to want to subject themselves to a just an unlimited amount of damages on the thing, and might choose to practice otherwise. So, do you anticipate, if were we to pass this legislation, that it would affect the entire medical society, or just a very limited number of? I mean, I understand somebody that does pediatric brain surgery, they would be very concerned with that.
Correct.
But an orthopedic, somebody, or a neurosurgeon, it would seem it would apply to all neurosurgeons.
Well, let me kind of address those. If it is you said there's a vast number of situations where this could be inflicted. I mean, and that is why we legislate, because if it's a loss that can be spread among a large number of people, we need to have a rule that dictates the value of that claim, especially after the Supreme Court's ruling. As far as insurance going up and down, I don't think we have any control over that. I mean, over the years here, we passed legislation that was promised an outcome, and it just didn't happen. Hey, if you pass gambling, we'll have the best schools in the South. That didn't work out. If you do this, then this will happen. If you pass tort reform under Foster, then businesses will come here in droves. I mean, I
voted on all that
well,
stuff.
I'm just trying to relate. So we have these situations where I'm not going to sit here on the table and say, you know what, this is going to make rates go down because marginal practitioners will have to leave the state. The hospitals will no longer give them surgical privileges because they have too many claims against them with babies. I could say that as a counter to insurance going up.
Yeah, but those marginal practitioners may not be doing stuff that would inflict this type of injury, but the general scope of their practice, I think, would cause their insurance company to rate them in a group that would possibly be subjected to the higher premiums. And I'm not saying the cap shouldn't be raised. I agree with you. If it was set in 1970, even if with a cost of living thing, it probably should have been raised. That's not my point.
But here's the thing: we're not trying to raise the cap for everybody that suffers from a catastrophic brain injury. This is only children.
No, and I agree with that. And don't get me wrong, I'm not unsympathetic to your cause. But my experience in this body is that this year we're doing that, and I'm sure there are other people in other situations that believe they have just as serious a problem with the cap as you do, and you have a real one. I'm with you.
And listen, when I read the Supreme Court's holding in the most recent case on this, they say we as legislators have the obligation to do the constitutional balancing test, and they've kind of said, look, guys, y'all can do it as long as you have a good state's interest reason to balance out taking away somebody's right to get full justice. And we do that workers' comp, with the workers' comp compromise, and we've done it in the med-mal compromise. And both of those have had to been tweaked over the years to make sure that the parties balance out. We just did major workers' comp reform, you know? And so let's go back to the neurosurgery, because that comes up a lot, and I've talked to a lot of pediatric neurosurgeons. Let me just tell you this. If you're a pediatric neurosurgeon, and I bring my child to you and say they have a tumor in their brain, that pediatric neurosurgeon sits me down, he goes, these are all the things that can happen once I take off part of your child's cranium, and I roll back the layer of protection to the brain, and I get past the blood barrier, and now I'm in the frontal lobe. Okay? Your child can become bipolar. Your child may not be able to smell things anymore. Your child may not recognize you through their vision. They may have to come touch your face because they may be blind. We're going to have them sedated. So they tell you all the things that are the standard of care that could happen. The way we protect the pediatric neurosurgeon who has a gift from God to work on kids with brain tumors and things, or spine tumors, is that typically those results are within the standard of care. And the panel is going to say, this was a horrible thing, this child had a brain tumor, it's within the standard of care that the child could die on the table. Okay? What this does, and we could use an OB type situation, or we could use an orthopedic situation, because those are where this usually, what I've heard, have come into play. Your child goes in for a rotator cuff surgery, they put him in the proper position, and your child's allergic to morphine. They give the child morphine. They stop breathing on the table, they try to resuscitate, it doesn't work, so they're out for 30 minutes. Global hypoxic ischemic event. The result is cerebral palsy, maybe one limb, two limbs, all four limbs don't function anymore. And it comes back to saying, hey, you know what? If the nurse just had positioned you properly, this wouldn't have happened. That was below the standard of care. Now, if you have one doctor say that in the panel, you have two say it was okay, the cap doesn't get raised. You have to have all three doctors say, wow, this was below the standard of care, and it caused the damage. We're not going to see that in I don't think we'll see that in pediatric neurosurgery cases, because if a doctor is cutting on someone's brain, that family already knows there's a chance of death.
Or they should know.
And they do.
Well, you say that. I mean, and obviously that is a good practice. But my experience, and I don't do med mal work, but I can assure you they're not going to sue them and say they didn't do anything wrong and they were within the standard of care, but I'm suing them anyway. So you're going to end up in court on it.
And it's a real emotional process. The families are emotional about it. The doctors are emotional about it. And that is why the safeguard is in there of the unanimous panel or the unanimous jury. Those are highly unlikely in the procedural process that we have. So,
and again, I'm not trying to at all be unsympathetic to what your situation is. What I'm saying is there are going to be doctors that are already calling us saying with the way that we're financing healthcare and a lot of them are just hanging up there, are quitting. And I think I believe, and again, I'm not exactly sure where we're going with this, but I think you're going to affect a tremendous number of physicians with a severe increase in malpractice insurance to cover a very limited number. And again, very serious cases. I'm not making light of the situation. I just think that you're going to have, I don't know how an insurance person can fix that rate in the abstract. You just say, well, you're an orthopedist. You could perform the same type of situation you talk about, and you could be subjected to it. So I got to treat you just like every other orthopedist, and your rates are going to go up. So that's just. And I'm just saying that back in '70, I think one of the reasons that the cap went on was to encourage so as to not discourage doctors from practicing medicine in this state. So,
I think you're presupposing two things that are theoretical, but in practice, when you talk to doctors and you say, look, do you feel like your patients should be at least fully compensated if the unknown happens during surgery and one of your staff members falls below the standard of care, gives too much anesthetic, doesn't position the perfect person right. And all doctors, and most of them go back to their Hippocratic oath and they say, do no harm. And they'll say, look, off the record, I'm okay.
Off the record, but do no harm, and on the record, do $500,000.
Right. And so here's the thing, Senator Martini, and I think what you've just done is what I've been doing, and what you just did is you attempted a justiciable balancing process of two rights of people. And we've created that fiction in Louisiana. And the state court has said we're forced to do that balancing test. And you've just balanced the doctor's rights and the patient advocacy, you see. And we have to continuously look at that. You know, I was so surprised that no one has we haven't raised the cap for over 40 years, you know, that no one has thought this through and said, you know, hey, this is a pretty unique way to handle catastrophic injuries. We've created no subclass in 40 years, and this is the worst of the worst. We're not talking about the majority of cases that get to the panel stage. We're talking about, on average, 4 of these a year. Now, if an insurance company says, out of the millions of surgeries we do in Louisiana every year, this could happen 4 times. So you're a urologist, I'm going to raise your rates $5,000 a year. Well, you know, that's a scare tactic, because we know just with basic underwriting analysis that you can't take a four out of a large number of surgeries and gouge rates like that. I think the doctors would say, look, this is a highly unlikely situation to happen, you know?
Well, look, I understand what you're saying, but I also understand this process. And if we are to pass this bill, you can't stand here and say, and I promise you, this is the only time we're going to deal with this issue, because somebody's going to come behind you next year and say, my damages are just as bad, if not worse, than his. And then I think as we start picking away at it, then you get into an equal protection thing saying, well, wait a minute. You know, we have doctors saying do no harm, and we've got doctors out there causing millions of dollars of damage, and they're protected by the cap, except in this very small number. And I'm not saying it's not warranted, okay? Except I think that number. I mean, I can see what's happening. We're going to get the camel's nose under the tent thing. It's going to be a yearly thing where we say, well, you did it for Ryan Gatti on his bill, and you did it for Rick Ward for his constituent. The next year, we're going to just start carving away. And I just think there are things that need to be considered. Sure, I'd love to see. There's no way, in my mind, knowing your story, that we can adequately compensate the Gatti family for what you're going through. I understand that.
Oh, and I'll let you know this.
And this isn't going to affect you, but what I'm trying to say, the people you're talking about.
And I'm going to speak to that because we've gotten a lot of those red love letters that they send you in your email. You know, like, you're crazy for doing this. This is a personal vendetta. I mean, this happened.
No. I think it's a personal observation, and it's.
And I'm going to tell you this. You know, Susan and I are in a unique position. We high school sweethearts, went to LSU. I proposed to her at the bell tower. I was Catholic, she was Baptist, so I said, we'll have a big family. They'll just all get saved. We had a lot of fun, all right? So we have 4 daughters, you know. We're pro-life, we're prolific. That's what I tell folks. So Rebecca is our 3rd child. We were told by our doctor that hurt Rebecca that there was something wrong with Susan's uterus. That's why this happened. 6 months later, we go to that doctor's partner after he's had several issues happen at the hospital. And I said, doctor, we just want to know one thing. Can we have other kids? He said, of course you can. There's nothing wrong with you.
Yeah. So
I'm telling you that there's a process that is buffered there that allows some bad behavior to happen. And it's significant. Now, this happened to us 9 years ago. I mean, our whole life has changed over this. And this is not about me, because you could pass this bill or not pass this bill.
Well, if I gave the audience the impression that I thought it was I just think it's a personal situation which motivates you to do it. And I don't mean that in any negative way.
No, and I'll tell you this, and a lot of what we do as senators is motivated by personal experience.
Well, of course.
Whether it's something in our district or a constituent concern. And Susan and I debated about whether they're even doing this, but there's so many folks that this has happened to who don't have a voice, you know. and they can't come down here for $16,000 a year and be a senator. You know, they're dealing with their child. I mean, I was going to prepare a statement to write this morning, okay, for an opening. And I realized, well, we had to get Rebecca up. We had to give her medicine through her feeding tube. We had to do all these things. And we decided we're going to drive over here. We're going to push her over here in the wheelchair. And I thought, you know, man, this is our new normal, you know. And I thought all the folks that are coming here to testify, they might have said, you know, those steps are too high, or this is too much. I'm just not going to come. So this isn't, I mean, Susan and I are way past, you know, this is our new normal. This is how we live. Our youngest daughter does not know what it's like not to be, I mean, she holds her big sister. Mm-hmm. You know, it is such a unique situation. God has worked through our testimony and put us in this place to share this information with you because, you know, what you're really doing is you're saying, I'm going to balance these situations as they come before us as Senate. I'm going to balance the justice that is there. And you know, as a dad, when a doctor wrote me an email, the only one that really got me was he goes, I can't believe you're doing this because it's personal and my assets are going to be at stake. And I'm like, yeah, I didn't respond because I know he was just talking out of a little bit of anger. He probably got an email from one of the red cards and they told him, your rate's going to go up 1,000%, you know, and whatever they said. And so they're fired up about it. But I want to tell you this, he's right in a way. Because you have to balance the asset of a child's brain to a family versus his ability to keep his assets. Okay? And I want to let you know something scary. When we're allowing direct access and some of the things we talked about, those are capped too. You know, all the arguments we just had on the floor, well, if a physical therapist says this is a pulled muscle, but it's really a cancer tumor, well, we can have direct access in a state with a cap. I mean, we've already agreed ahead of time. That mistake is only worth $500,000. And the practitioner has to pay $100,000 of that. So we're kind of have this snowball effect going, but you didn't bring up that this was a personal thing for us. Other people had. I don't want you to think that I...
And I surely didn't mean to insinuate
Of course not.
that.
I understand that.
You know, so.
Yeah, but I will tell you this. Susan and I have advocated on this for a while. We've met with many families with special need kids from birth injuries or orthopedic injuries, and we love on them, we care for them, and then we kind of commiserate, you know. And it's not about money, you know. It is not about that. On the plaintiff side, I mean, when you have a child with severe cerebral palsy or who's a spastic quadriplegic, I mean, you know, at some point you just say, I'm going to file bankruptcy or I'm just all in. You know, I'm going to spend everything I have to keep her where she wants to be. It's the families that can't afford it that we're really advocating for, you know. And they go in and it's a routine thing, and the doctor weeps with them and says this is horrible, and they get forgiveness and they give forgiveness and they make it through, and then they sit down with someone and they say, hey, and they sit down with some lawyer who tells them, hey, in 1970 they decided your child's brain was worth $500,000, and you literally add insult to their injury. And so what this bill does, it just carves out the worst of the worst. And once again, I think that anything we do will be used by the insurance industry to raise rates. Anything we do. I mean, every bill they look at, I mean, I've had discussions with my other bills that I have to decrease the rates of businesses, and they say, well, even if your bill passes, we're not going to decrease rates. And so, you know, and that's just the nature of the beast here in Louisiana. So, anyway, this is my notes to say I have one line, so everything I've said has been...
Well, we do have another question from Senator Luno.
Thank you, Mr. Chair.
Thank you, Mr. Chair. Senator Gatti, I'm gonna ask you to do something for me. If you don't want to, it's okay. I don't think a lot of people understand what we're talking about here would happen. I'm going to ask you, if you would, to share what happened with your child and your wife. If you don't want to, that's okay. I know that may be very difficult to do.
Well, you know, it is difficult, but, you know, we've had 9 years to kind of process this. And so if you don't see me cry, please don't think, well, that guy doesn't love his kids. You know, just know that we have talked about this in church. We've talked about this with other families. So Susan's going to get mad because I think she wanted to tell the story, but I'm going to do it because I know she doesn't like talking about it. Okay. On April the 24th of 2007, we went into the hospital to have our third child. I was at dance class with my two older. I wasn't dancing, but it was my job to take them to dance class. I look like a bear down I dance. So I was at the dance class with them. Susan called and said, "Hey, doctor's concerned." She was 38 weeks. She says he wants you to come in. So I called my mother-in-law, which is always a fun situation, to have her come to dance class so that I could go to the hospital. So I go up to the hospital, and the doctor decided to break her water early, and it was just one of those processes. And to make a long story short, there were about six. Well, the panel agreed there were at least 3 opportunities for him to do a C-section that would have lessened the hypoxic ischemia or the non-oxygen to the brain injury that Rebecca has. I was in the room as a dad, videoing. My 2 oldest daughters, we were 7 and about 5 at the time. We're in the waiting room with all of our big family, videoing, interviewing people. Hey, baby's going to come here, come soon. What do y'all think? That was about 5 or 6 o'clock. And about 9 o'clock, Susan's blood pressure fell. She turned white as a sheet. She needed oxygen. The nurses came in very concerned. About 9 o'clock, she had what's called late decelerations, which is when the fetal strip shows the baby's in distress. Without getting too technical, there were some decisions made. I remember vividly the doctor saying, well, those external monitors are not working. That's the problem. So when a baby's being born, when they're down in the birth canal, they put in an internal monitor on the baby's head before they're born. That way you get a true reading. Well, we found out later that when he did that, he misplaced the internal monitor not on Rebecca's head, but on Susan's cervix. So he was actually reading Susan's heartbeat instead of the baby's. A couple hours later, Susan's blood pressure began to fall, which is a classic sign of a rupture. It means the blood that usually goes through the placenta to the womb. It means that there's a leak, but it wasn't a open rupture because Rebecca was already down in the birth canal, so she was kind of acting like a cork. The blood was pooling behind Rebecca in the uterus, and portable ultrasound was brought in by the nurse. They put it on the baby's on Susan's tummy. Even though the reading was 120, which is normal, the portable ultrasound read 50 beats a minute, which is horrible for a baby. And so there was kind of a freak-out mode. There was nobody on that wing of the hospital. We found out later an orderly was called to help with the delivery. The anesthesiologist, who did an excellent job in resuscitating Rebecca, he was very devastated. The doctor was devastated. Did a C-section. They called for a C-section. It took 28 minutes to get Rebecca out. We found later out at Dallas Children's Hospital when we were there with a neurology team that it should only take about 3 to 7 minutes. They have like a team always on call to get a baby out in distress because of this. When they finally got Rebecca out, she was dead. There were 2 units of blood coagulated in Susan's uterus, which means she'd been bleeding for a while. And there was a unit that was free-floating, so my wife had lost almost 3 units of blood. I did not know Susan's life was in danger. I was never told that until afterwards. They measure a baby with APGAR scores, which is a 0 to 15. Are they breathing? What color are they? How are they responding? And 1 to 5 on each of those. And different hospitals do it different ways, we found out. But she was 0, 0, 0 at 1 minute, 5 minutes, 10 minutes, and 15 minutes. So she had been dead for 15 minutes. They revived her finally. She immediately started bicycling. They call it a bicycling seizure. So she would move her. She's a baby. She looks just like my oldest daughter. Spitting image. You put their 2 baby pictures together, and she and Catherine look exactly the same. And so she began bicycling her arms and legs. And, baby doesn't do that. We all have kids. I mean, babies don't do that when they're born. And so I went to the NICU. Susan stayed at the hospital, and they were at separate locations. And that's when we kind of got the news. A friend of mine that's a neurosurgeon called me. He said, I looked at the MRI. It's black. I said, what does that mean? He goes, there's just nothing there. She's a vegetable. And so we kind of had hope, and we had prayer, and we called all of our friends, called in all of our favors, called in everything we could do to help her get the best care possible. Susan, being a PhD psychologist who had worked with kids with brain injuries, she knew the outcome. I did not understand it, because most people I knew that had strokes or brain injuries had recovered. They had been able to have some quality of life, So we found out we found out it was the worst case scenario. We got to Dallas Children's at the ER one night because Rebecca had had a seizure for about 24 hours, and it wouldn't stop. And we left the Shreveport Hospital. I called a friend in Phoenix. He said, get to Dallas Children's. We'll have somebody there to look at her. Because she was hitting milestones, but because her brain was kind of fried, it was just it was just totally dysfunctional. And we couldn't figure it out. And so we got to Dallas Children's, and the first question they asked me in the ER was, did you have this baby in a hospital? And I said, yes, sir. He goes, this is pathetic. Pathetic. And so anyway, it was a pretty tough time for us. None of this was done intentionally, though. I mean, it was just a mistake. I mean, we know to this day, by praying about it, there's no way anybody meant for this to happen. That's not what the Med-Mal Act is about. This was just one of those situations that was really bad. Now, since then, we go to Shriners, we go to different places, we try to get Rebecca the best care and the best comfort. One night at Dallas Children's, they asked me to sign a DNR because she wouldn't stop having seizures. I mean, bicycling seizures, clonic seizures, tonic seizures. She wouldn't keep anything down. Even her medicine, she would throw it up immediately. And, she's a baby. I mean, she's like less than 6 months old. And so they said, Dad, will you sign a DNR? And I said, look, I'm pro-life. I'm not going to do that. I want y'all to fight for her. And so we made it through that. And, she's still here today. She's had, I think she's had a pretty good life. We take care of her the best we can. We've hired somebody to come to our house and sit with her, Miss Kathy, who is like Alice and my favorite. Like, if you could dream of your favorite mother-in-law, that's Miss Kathy. She loves me. She cares for the kids, but she loves me. And she came to us just sitting by God to be at our house every day. It allows us to have some freedom with our other kids. A lot of families don't get to have that. I got to coach softball. I got to do a lot of things with my older girls to make sure that their depression didn't grow and grow and grow. And then we had Charlotte, which was kind of a surprise. And so, but anyway, our story is no different than anybody else's. Can we articulate it a little better? Probably. But as we meet more and more folks who have suffered through this, it's a tragedy. And I'll tell you this, Senator Luno, and what we found over the years is that this is not training issue. This is because the cap is so low. Sometimes this happens. If we would have been on vacation in a state without a cap, I don't think this would have happened. Don't think it would have happened. We have a high rate of medical malpractice claims here in our state with a cap and with a procedure that is tough. So, but I'm not here to bash the procedure we have. The Supreme Court has said we have the right as senators to look at this and work on it and determine if there's classes of people that should get more or classes of people that should get less. And so, anyway, that's kind of a peek into our story, but it is tough to talk about. And honestly, a lot of people that were coming today just said emotionally, I can't talk about it. Right. Ryan, you tell your story, you advocate for us, but we're not going to come.
I appreciate that, Senator.
Thank you. And I'll just add we had a unanimous panel. The panel unanimously said, we agree this fell below the standard of care. and that her brain injury was caused by the doctor's decisions. Now, please note, we had to have genetic testing done, because at first they told us that's what it was. We had to have Susan examined because they said your uterus is tilted and you have a propensity for placental abruption, and that was ruled out. Can't have any other kids because of the biology of your family. I mean, I cried that day when we found out that we could have other kids, because I really thought that was kind of a low blow to us, to try to lead us on in that way. And then we found out that other people have gotten the same kind of stories. Hey, it was your anatomy. That's why this happened. And so we're finding out, those things. So, and once again, some of my best friends are doctors. They do excellent work. They care for their patients. One of my friends slept at the bed of a mother for 2 nights to make sure that she was cared for after a horrible birth situation where she showed up at the hospital abrupted. He stayed there in the room with that baby and the mama praying over them. You see? And that wasn't a breach of the standard of care at all. He was there 100% with that family. So anyway, I appreciate that question.
Right now, I don't think we have any more questions for you. We do have some cards in support, some that would like to speak. Ms. Susan, would you like to come forward and speak now? Also, we have here in support but not wishing to speak is Benjamin Mouton. We have Chantel Nixon with herself and her son, Kay Swan. And then we have also here and would like to speak. And then we have Scott Weber is here but does not wish to speak.
Say your name and address first.
Yeah, if you just would
I don't
identify
believe
yourself.
anything he says, so I'm going to follow your lead. Does that work?
Yeah, if you could just identify yourself
Okay.
For the committee, and then you can go from there. I don't think your address is necessary, though.
Maybe changing soon. No, my name is Susan Gatti. It's probably just as well that Ryan gave you the spill on all the medical terminology for the history of my child, because I kind of gave up on that a long time ago, but him being the researcher and the intelligent one he is continues to do that. I think the best way for me to present Rebecca to you, other than I think most people can't understand her until they do meet her, because she is quite unique. We're used to the stares, we're used to people looking, we're used to the different comments, we're used to, oftentimes people will think that she's an infant because of the brain injury. Her head is so small and she likes to be cuddled up in my arms. So there's a lot of mistaken things, and we're accustomed to that. But one of the most often questions I often get are from kids. And I appreciate that, because I always appreciate kids' honesty. They ask what's wrong with her. And the way that I best explain that, and I think maybe the best way, is I say her brain is hurt. And they say, kind of look at me confused. I say, well, what does the brain do? And they all say, well, the brain is how you talk, how you think, how you move, right? Because when you injure the brain, you injure everything, right? So that's basically what happened to Rebecca. As a result of the birth and the mishaps that happened during that process, her brain was so significantly injured that she, when you met her, I know many of you were probably confused, but she is not able to see. She does have cortical blindness. However, her hearing is intact. And so when she hears a different voice, for example, Senator Luno walked by the other day and spoke, and she kind of jumped because she can hear. So her hearing is very well intact. However, she really does not have any functional movement of her body. She can lift her head for a few seconds at a time. Never reached a developmental level of more than a 1-year-old because she's never received that social smile. So as a parent, we don't get that reciprocation for now. I had things planned. Yeah. In terms of when he spoke about the unanimous panel, I can remember the day that the unanimous panel came back for our child saying that, in fact, all the concerns that we had brought forward were legitimate. The physicians on that staff had also brought into that meeting additional concerns and additional problems that they had seen with it. And I remember at that day, because I think oftentimes people have a perception of persons as pursuing financial gain as a result of their child's injury. And I can remember that day vividly because I remember sitting in my husband's office and I remember crying hysterically because all that I really wanted to hear back from that panel was that that doctor had done everything he possibly could for my child. You know, I didn't want the money. I didn't want anything else. I just wanted the peace of mind knowing that everything had been done for her that could have possibly been done. As it turns out, that's not the case. So we got the lesson in forgiveness, which we have given, which is the greatest lesson that we've received. But having a child with a disability, and how would you label her disability? Formally, well, you could say that she has uncontrollable seizures, so she's an epileptic. You can say that she's a spastic quadriplegic because of the orthopedic impairments. The brain injury has done a significant amount. For example, when you look at Rebecca, the size of her head, like she can still wear an infant cap because the head grows as a result of the brain growing within, but because so much brain matter was lost in that initial injury, her head is much smaller. Even to her teeth, I call her my little British baby because of all the seizure medication. Her teeth are very yellow in spite of the best care that she can have. She's unable to cut through teeth, so they sit there and she drools nonstop all the time because she can't cut her teeth because she can't eat. What else? The greatest concern that I have for my child and the biggest impact that it's had on her are all the neuromuscular issues that she receives as a result of this. The technical term for it is they call her hypotonic, because if you were to take your arm and twist it like this and hold it as hard as you can, as long as you can, that is the state that she basically stays in. So it deforms her body to the points where her hips are twisted and completely out of socket. So when you look at her, she has scissored legs and her hips stay out of the joint and kind of move around within her body. You can actually see the tops of her femurs whenever you change her diaper. And that, I think, is my greatest concern for her, is the physical discomfort that she receives on a daily basis as a result of that. She does have uncontrollable seizures, but it's crazy at this point in my life. The seizures really don't bother me. It's more of the muscular pain that she has as a result of all this. I outline that to say the burdens that the families of victims experience are extreme. They're extreme emotionally. They're extreme behaviorally. They will put pressure on a family to where the family dynamics of children with disabilities, not many families survive that, not many marriages survive that because the burden is so great. And if there's a way to relieve the financial burden that adds to that stress in a way that is more just for persons, I would love to be able to see that for the families that I've encountered. Because as we went through this campaign trail, I believe that the majority, I didn't realize why I was on the campaign trail as much as I was, but every time I went, everywhere I went somewhere, there was a special needs family member represented somewhere. There was someone that had a story about their child. Even as I sat here watching the TV with persons with disabilities later, you know, there's a burden for us to care for the disabled, and how we care for our disabled indicates how we are as a society. And I do think that it's just for persons to help in that process that are a part of that. Does that make sense? So for when your child is hurt and they look at you and they say your child's worth $500,000, you know, I've often heard my husband witness to many people, and he has said, you know, would you sell me your eye for $1 million? Well, no, I'm not going to sell you mine. Would you sell me your arm for $1 million? Well, no, I'm not going to sell you my arm for $1 million. Why? Because it's precious, right? So as a parent, as a mother, I would never wish this on anyone, okay? There is, like y'all have said, there is no financial compensation that makes it okay. There's no financial compensation that any of you would take to say, if I gave you this amount of money, would you give your child this injury? Nobody in their right mind would accept that, right? But having said that, I do think that there should be a just process in place. And I do want, for us personally, because it has been said that we are on a personal vendetta for this. We have no vendetta. We love our child. She's changed our lives drastically. She has brought perspective that we call our 1,000-year perspective, in terms of whenever we look back in 1,000 years, the lifetime that she would have spent here will just be a blink, just be a dot on that line, and we'll have eternity with her. And she is my only child that can't mess up her eternity, in my opinion. The rest of them are up for grabs because they make mistakes all the time. But I don't know. I mean, I don't know what else to say. I didn't really prepare very well. Yeah, thank you.
Well, no, thank you. I know this wasn't easy. Personally, whenever people would maybe attack you through emails or something for bringing this bill, I take a little bit of offense to that for you, because I think sometimes we come here not necessarily knowing why we were sent here, mm-hmm. and then we find out along the way that maybe this is something that I can shed some light on, whether it be this issue or other issues, and you do take that chance whenever you're willing to bring it forward. And regardless of what happens with this bill today, I think it's very important that we hear this particular side of it. And so thank you for being willing to deal with those things in order to have this conversation.
Well, and I do think, as he said earlier, it is personal, but I think most people, I watched someone from the floor last night advocate for a bill about engineering. Why? Because it's her personal experience, mm-hmm. and because she knows from her personal experience how to make it better. So I think oftentimes we wonder and we pray, why is Rebecca still here? Why is she continuing to suffer? And I know that God's plan is better than our plan for her. And I know that she is still here as long as there is a purpose for her to be here. So if this is part of her purpose, to shed light on injuries that can happen and how drastic they are to children and how they can affect families and siblings on all kinds of levels, I would hope that she could do that. Hopefully people will be able to look at our family and see how she strengthened us in many ways as well. And it is an opportunity for us. I appreciate the opportunity that she's given us to be able to help other families with special needs members, because like my husband said, I am a psychologist, work with children with disabilities all the time, never planned on having a child with a disability, mind you. I don't think any of us do. However, it's made me a better psychologist, because you can never really understand what it is that families go through until you experience it yourself. So thank you for your time.
Thank you. We have Miss Chantrell Nixon that's here and would like to speak. We also have James Click that is with, I believe, Miss Nixon, and is here as well.
I'm her lawyer. Thank you.
Thank you.
Good morning.
Good morning. You can identify yourself and then you can speak.
My name is Chantrell Nixon, and I want to start off by saying I'm very emotional, okay? So I am going to present tears just off of his story alone. When I see parents that go through the same thing that I go through, and I feel very, very thankful because we actually have someone that understands what we go through to advocate for us. So whether someone feels like it's a personal vendetta or not, I think it's awesome. You know, I say this all the time. You never know what a person's going through until you walk in their shoes. Everybody has different shoes. Everybody has different walks of life. And just going off of someone telling you, their story, or you kind of seeing but not seeing, you never know how a person is internally. And the things that we do as parents with special need kids it is a job in itself. Being a mother, period, is a 24-hour job. But when you add a kid that has needs and you have to be there, there's not enough hours in the day to compensate for that. And I think that, to speak on what Senator Mark was saying about the insurance claims going up and all of this, creating a domino effect of other people coming in saying they want their cap removed, or all of that. I feel like what Senator Gatti said was correct. It'll kind of like wean out the ones that's not performing the way they should. If you do raise them, maybe that's what they need to raise their medical malpractice insurance. Then some of the things that's happening won't happen. Maybe they'll do their procedures, with a fine tooth, or look over everything, think about everything that can possibly go wrong or not go wrong if they do something different, and not just pass it off as, like I was passed off. I was paranoid. Maybe if I was in a different situation where I had better doctors, or they had that higher insurance, she might have said, well, maybe I should look at this kid a little closer. Maybe I should listen to what the mom is saying, and if that's something that has to happen, then it has to happen. Like he said, insurance company raise insurance for bad weather, for anything that they think of, they'll adjust your rate. So why not have it to where we can wean out doctors that don't perform, to their standards, when we have phenomenal doctors. So, and I'm a hard worker. I was a hard worker before I had kids. I'm one of those, I'm the mom that had to file bankruptcy, because when I had my child, there wasn't a doctor that was going to tell me that he couldn't walk, and I wasn't going to listen. I wasn't accepting that. I was told that he wasn't going to walk. I was told that he wasn't going to talk. He wasn't going to do these things, things that a normal kid should do. And I remember when the doctor told me that, and she said, Miss Wine, did you hear me? And I told her, I said, yes, I hear you, but God might have a different plan for him. And as long as he has me, I'm going to fight for him. So yes, I was the parent that filed bankruptcy to take my child twice a week to Mandeville, which is 2 hours away, and pay for some specialized therapy that I had to pay for out of pocket, with the help of my church, my family, my church, people that did donations and stuff like that. And then just so happened, my aunt, she saw the same therapy that we were doing in the hospital in Lafayette, and she lives in Lafayette. So that made it easier. We still had to travel, but we had somewhere to stay. We didn't have to go back and forth. So we do what we have to do. Now, had I not been capped, I wouldn't have had to stop working. I could afford to pay somebody to stay with my child. I'm not as fortunate. I don't have Miss Catherine is her name. I don't have a Miss Catherine, but I do have a Brianna, and she's awesome, and Kai loves her. But she can only do so much. I do have a younger son, and like Senator Gatti said, she makes it possible for me to be a basketball mom and, travel and do things with. But with me, and they probably battle with this too, I do not feel comfortable leaving him. Okay? So we all have to go. She comes with us. He'll look, That's one of the phrases that he's learned. Go take a ride. He knows that, if I call my dad and he tells my dad, go take a ride, my dad is coming, take him for a ride. I do not like to leave him out of anything. I try to make his life as normal as possible. As normal as possible. And if it's a thing that I have to leave him, I feel awful. And he's getting to the age now, he's 13. He's getting to the age now where he knows that, we're going. And it's been time that he'll sit and just wait for us to come through the door, And so he has a little brother, and like Rebecca's little sister, he also takes care of his big brother. He is an awesome little boy. Most of the time. But as far as his brother is concerned, the brotherly love that they have, like Kai will literally go and lay down and go to sleep on his brother. And so he'll take him, come on brother, let's go to bed. Kai also has seizures. The little brother, Mama, what do I have to look for? I was afraid to have kids after I had Kai. I really was. And I was afraid that what happened to me would happen again, and I didn't know how I would handle it. But like she said, God does things for a reason, and God put my younger son in my life for a reason. And he steps up with his brother, and he literally helps take. He was the one at 2 years old, 3 years old. He's been walking since he was 9 months old, my 7-year-old. He's been walking since he was 9 months old. He was the one that helped Kai learn how to walk. I was in my bedroom, and I'm hearing him saying, come on, brother, I got you. And he'll take 2 steps back, and he'll make Kai walk those 2 steps to him, and he got him. And I watched him do that for at least 3 minutes. And so, I think Kai seeing him run around, kind of got him like, my brother's not going to leave me. So, a lot of things that my younger son does, Kai kind of mimics. And his brain injury was, severe. And I was told that you have to look at it as the older he gets, his brain has to catch up. Well, he's still functioning in some aspects as a 24-month-old, and he's 13. And I totally agree with this what is this bill that's he wants to get passed. And I just it would help a lot of families that are in need, and it'll make life much easier. To, like I say, you all may not understand exactly, what we are talking about, but I know I see the compassion that you all have for him, because y'all actually see what's going on with him, but you're not, you see it, but you're not in it. It's totally different when you're in it. So that's all I have to say. Thank you.
Thank you, Ms. Nixon. Thank you for taking the time to come.
Thank you for having me.
Would you like to speak?
Well, I just have a couple of comments, and one of the comments is there's been expert testimony in cases that has indicated that increasing the cap is not going to result in any significant increase in insurance rates. Also, there's been no change in the number of physicians when the cap was established between what the number of physicians that we were having. We had increasing numbers of physicians in the state of Louisiana prior to the enactment of the cap, and that same increase continued after that. So we have evidence along those lines. If ever you all want to have a real serious discussion about that, you know, we can present that evidence to you and address that.
We do have a question for you, if you don't mind.
Sure.
Senator Milkovich.
Thank you, Mr. Chairman. And Attorney, tell me I heard your name. Did you say Mr. Glick?
Click, K-L-I-C-K.
K-L-I-C-K. And your first name is?
What's that?
Your first name is?
Jim.
And where do you practice, Jim?
I'm in New Orleans with Herman Katz.
Gotcha. I had a quick question. Maybe a quick answer, maybe not.
Yeah.
You said that the experience has been that when the cap is removed, insurance premiums do not go up. What's your analysis of why an increase or removal caps does not increase rates? What's your analysis of why that is?
Well, for one thing, the states that have no cap on it actually have lower insurance rates than the states that have caps. There's a whole body of evidence. I mean, there have been trials on this whole issue where they presented many of these things and have gone through it, the evidence. And as I said, if you're really interested in it, I can go get it. I wasn't involved technically in those cases, but I can probably get the evidence and show it to you.
Sure. Well, and that information is important, obviously, because it has to do with the compensation of people that get hurt. And what is your contact information, Mr. Oh, you said you're with Russ Herman's law firm?
Yes.
You said that removal of caps does not increase premiums. I'm not sure you said why. And I'll suggest a thesis, and I don't know if this is it true that when caps are removed and there is more accountability in the system, that there's greater care shown so that there's less neglect? Is that?
That's exactly right. And that's the reason why the states with no caps have, generally speaking, lower malpractice insurance rates than the states that have caps. And it's one of the reasons why and you see it here, the cap hurts the most significantly injured people. You know, people that get the regular injuries, and the most significantly injured are a small number of these people, okay, to start with. It's a very small number. And so once you start, you're allowing the people who don't have the real significant injuries to get full compensation, but you're harming the people that have the most significant injuries.
This is potentially important information, Mr. Click. Thank you very much. Thank you, Mr. Chairman.
One more question, sir.
Yeah.
Mr.
Sorry, I apologize.
Senator Luna has a question for you.
I apologize.
No
It's
problem.
okay. Mr. Click, with Ms. Nixon's permission, I didn't ask her to tell what had happened to her son, but with her permission, could you tell us, or could she?
I would. I
prefer
can't
she-
go into that.
Okay.
Because she can talk about the afterwards, because that was a full trial on the merits, public
Sorry.
trial.
We won't put you in that position. Thank you.
Thank you.
We do have some cards in opposition, as well as some cards that are here for information purposes only. I think we're going to start off with the information cards. We have Ken Schneider with Patient Compensation Fund. We have Clark Kosei with LAPCF, also here to provide information.
Gentlemen, I'm Clark Kosei. I'm the chairman of the Patients Compensation Fund. I've been on the board now for 12 years, and for the last 10 years I've served as its chairman. I want to start off by saying that we approve more than 99% of the cases that submitted. I've only remember one case that we have actually not approved a settlement on, where we thought we were not getting a fair deal. Just put it that way. I also want to tell you that on the micro spectrum that we've had today, our hearts are broken about 10 times a month on cases that show facts like these. But it's not our job, by the way, to punish doctors. We are not the licensure board. There's a licensure board called the Louisiana Board of Medical Examiners that gets reported from us on any claims that we pay, and in which has the opportunity to have hearings and decide on whether or not that doctor is fit to continue practicing. Not our job. We do experience rate doctors that have substantial amounts paid out over and what they pay in to the patient's compensation fund. We're not an insurance company. We're state created, and the law that we have has been criticized many times. But we didn't write it. It was written by the 75 legislature, but they didn't write it either. It was basically taken from Indiana in 1975, word for word, and where the word Indiana was, they scratched it out and just inserted the word Louisiana. So it's a little foreign when you practice med mal to when you compare it to the law that we have in other areas like 2315 lawsuits and automobile torts. A doctor can pay what a surcharge can get to be 50%?
Yes.
They can have a substantial surcharge based upon their losses to the fund. Now remember that scheme, we have two levels, we have two layers. We have the underlying, which is the first 100,000, and we have the next 400,000, exclusive of judicial interest and medicals for the claim. The defense of the claim is based upon the 100,000. The underlying insurer or self-insured is responsible to defend the claim, not the patient's compensation fund. We basically have to pay the bill, but we don't get to defend the claim in most cases. When we first started up in 1975, it was a checkbook, pay in, pay out, and very little insurance type concerns. We didn't have, they didn't have, I wasn't involved in, but I've learned a lot about it since then. However, over the years, there was a large bit of concern that if we were insolvent, that there would be a hickey put on the state, that the state would have to bail out the fund, because we were a state institution. We had state employees, we still do. We have state civil service, we still do. Although not $1 of the money that is in this patient's compensation fund is state money. There's not one tax dollar involved. We pay all of our bills with the surcharges that we collect. Excuse me. So the concern about that was a concern of the Department of Insurance. And in fact, there was pressure put upon us to make sure that our rates were adequate and that they were actuarially correct. And to that end, the Patient's Compensation Fund added extra rate on over and above the amount necessary to pay the claims in order to cover that unfunded liability. When I arrived at the Patient's Compensation Fund in 2002, I think it was, the unfunded liability of the Patient's Compensation Fund, just like the state's unfunded liability for its retirement systems, kind of, was over almost $500 million. It meant that there was a potential that should the world end and we stop receiving money in the surcharges, that there would be $500 million we couldn't pay. So we added rate every year in order to start covering that unfunded liability. And in fact, I went to see the commissioner a couple of years ago with the good news that despite the fact that he was concerned about that, we have covered our unfunded liability. So today, if we were to pay all of our claims to the ultimate, which is an insurance term, to the end of the line, we would be able to cover them. We were also concerned about being swept. During the last administration, there was a lot of talk, and in fact, a lot of independent or quasi-governmental entities like ours had their funds swept into the state general fund to pay the bills. and a very large amount of money, all committed to case-based reserves. They committed to claims that we have or will have. Should not have been swept. And so the legislature passed a constitutional amendment and sent it to the people. And although we did not spend a dime on passing that constitutional amendment, it passed by, I think it was like 52%. Not a landslide, but we didn't spend any money. And basically got newspaper support in Shreveport and in Baton Rouge. We didn't get the paper in Monroe. I don't know how Shreveport and Monroe split up, but we didn't get the paper in Monroe. We didn't get New Orleans. But we did carry most of the other big papers, and that's how people vote lots of times on constitutional amendments. The constitutional amendment did a couple of things. One, that it separated our money from the state budget. So we're no longer in House Bill 1. We're got our own pile. Secondly, it said that if we ever got into a situation that there would be no hickey on the state, that the state is not responsible to bail us out, and that we couldn't send them a bill to cover our losses, and that we had to be, to that end, we have to be actuarially adequate. We have to have rates that cover the losses according to a properly credentialed actuary.
Mr. Kosei, and you may be getting there, but just for the purposes of time, could you kind of
we're going to get to
your
the cost.
comments to how
Right.
this bill would affect?
Well, and that's my next point, and that is that we have to make sure that we cover our losses. So I'll stop there. You know, you see now that we have this responsibility, and this is Ken Schnauder, who has contact with the actuary about this legislation.
Thank you, Mr. Chairman, Committee. I'm Ken Schnauder. I'm the Executive Director of the Patients Compensation Fund. When Senator Gatti filed his bill, I knew that there would be information needed on rates. So I immediately contacted our actuary and had him run numbers for the benefit of if this bill passes in its current form, what effect it would have on rates at the PCF. The majority of the claims that are paid, majority of the dollars, majority are Patients Compensation Fund dollars. Granted that we have $400,000 plus all of the medical bills beyond the $400,000 that we cover, as opposed to just the $100 on the primary side. Give you an example of if you raise the cap from $400,000 to $4.9 million, excess of the 100. Just that increase in the potential, the limit, would cause a 4.5% rate increase across the board for every enrollee. We have 23,000 enrollees in the Patients Compensation Fund. What that is, that's without a claim ever being filed that hits this 4.9 million excess. That's simply like you taking your auto insurance and going from a 25/50 policy to a 100/300 policy. Whether you have a claim or not, the charge for that, the potential for the claim is there, so the charge is more. So that's a 4.5% increase across the board on every provider. For every $5 million in claims that we would pay, whether it be 2 claims at $2.5 million or whatever the scenario for frequency, but for every $5 million we pay would be a 3.6% increase across the board. Now, as Senator Gatti mentioned, we have an average of 4 severe brain damage, minor cases a year.
Minor, M-I-N-O-R. Younger than children.
Children.
Right.
So, you know, the actuary, if you took, say, 2 cases that went to $5 million or 4 that went to 2.5 apiece, whatever the scenario, but you spent $10 million, that would be 7.2% increase plus the 4.5 that's already there. So it would be a minimum of 12% increase across the board. I'll put that in perspective for you. An internist, family medicine, that would be about a $1,500 a year increase to their medical malpractice insurance. An OBGYN, it would be about $5,500 to $6,000 a year increase. To a large hospital group in this state, it could be $5 to $6 million in increases. And you say, well, why would it be across the board? Main reason is virtually anybody can have a brain damaged child claim. I've had them on dentists. We've had them at hospitals. We've had them for internists. We've had them in emergency rooms. I mean, you can't segment out who could potentially have the claim until such time that you have 10 years of credible data that shows you where these claims have occurred. So that's the financial impact on the Patient's Compensation Fund from a rate standpoint, which goes directly to the healthcare providers in the state. Their costs immediately go up.
How do our rates compare to other states, and specifically maybe with states that have higher caps or states that have the same lower caps? I mean, overall, where do our rates lie?
Our rates are, for years, we were in the top 20% in the nation. But let me reference something. If you look at numbers, that's more from our law and our litigious state, because our auto insurance rates are always in the top 5 in the nation. Our homeowners insurance rates are always in the top 5 in the nation. Our general liability rates are always in that segment. So you're not really comparing apples to apples when you compare us to other states, because we're a different state altogether. But our medical malpractice rates have come down since we have claims have dropped over the last 5 to 6 years. Our rates have dropped 40% across the board over the last 6 years. But we are still about at the 50 to 60%.
What's caused the rates to drop by 40%? Is there anything that shows why that?
Our claims frequency has dropped, but it has nationally as well. But it has dropped in the state. Also, the board has taken the position that once we became funded to where we have enough assets to cover all of our losses, then we're not going to charge rate higher than that amount, even though the actuary says we should. Last year, the actuary said we needed a 3.8% increase in rates. We gave a 13.9% decrease across the board because we had reached a level where we have enough assets to cover all of our losses at this stage. That could always change. It could go up or down from this point. But, medical malpractice insurance is a large cost of the healthcare system. So, we're not an insurance company. We're not in the business to make money. We want to provide the best we can to the healthcare system, being it paying claims and reducing the cost of medical malpractice insurance for the healthcare system.
Just to give you some, I want to address that question, please. There's a publication done by the insurance industry called The Monitor, and it compares not workers' comp, medical malpractice rates among the states. And over the last 8 years or so, I had a study done of that study. And for years, we were neck and neck with Texas and Mississippi, and far below Arkansas. The only state in the South that we were not ahead of as far as costs concerned was Florida. And in Florida, it has no cap, and Florida has substantial numbers of med mal cases, and it's very expensive, maybe twice as expensive, or 50% as more expensive than Louisiana. Texas and Mississippi both adopted caps on non-economic damages in the late 90s or the early 2000s. Their rates went down substantially and were below ours. But since we have gotten funded, and funding the losses was part of our biggest problem, since we've gotten funded, we have been able to lower our rates, and I think we're competitive. And our goal has always been to be competitive with our neighboring states as far as costs are concerned, but we'll never be where Arkansas is. Arkansas is substantially more efficient, if we use the word, as far as malpractice costs are concerned, than Texas, Louisiana, or Mississippi. So that's partially answering that question.
Senator Milkovich has a question.
Thank you, Mr. Chairman. I think I want to start on a point of agreement. Would you all agree with me that Louisiana is some of the finest physicians in
Absolutely.
America?
Yeah.
And would we also agree that sometimes you can get bad outcomes when doctors have done everything they could and really probably done everything right? Do we agree with that?
Certainly.
In other words, some bad things can happen in medical settings without medical negligence, but because of the complexity of medicine, because of the innate condition of the patient, because of the factors of different pathological processes. In other words, you can have people that do poorly in medical care without doctors making any mistakes at all. Do you agree with that?
Yeah, I have a personal experience like that. I'm walking around with a drill bit in my knee. Not the doctor's fault, but when we got it, he's the best doctor I could find in Baton Rouge to do my knee surgery. And the first thing he told me was the drill bit broke off, and if we took it out, it would cause you a lot more trauma than leaving it in. He didn't do anything wrong, but perhaps the drill bit was defective. I don't know.
If we can talk and try to be as focused as possible, the funding mechanism is that the first $100,000 physicians are self-insured, and after that...
No, are insured.
Are insured, I'm sorry. And the second tier of coverage, the $400,000 that the PCF supervises, is paid by physicians or by liability insurers?
No, by physicians. Physicians, hospitals, nurses, whoever the qualified provider is. You qualify by securing your underlying 100 and paying your surcharge for the next 400 plus medicals and judicial interest.
If you are the business manager for a physician, how does that cost break down? How much are they paying to the liability insurer for coverage, and how much are they paying to the PCF?
The numbers are just ballpark, but
that's what we need.
The first 100 usually costs 50% of the cost, and the next 400 cost another 50%. Next 400 plus,
Okay, so the liability insurers, half of the money paid by physicians for protection from medical liability claims is paid to the medical liability insurers for $100,000 of coverage, and then the second 50% is paid to the state PCF fund for the next $400,000 worth of coverage. Is that?
That's correct. That's ballpark. I mean, it may change by class, but that's the information I get from our surcharge payers, subscribers.
Now, is it not true that the standard medical liability policy that's sold to physicians in Louisiana typically provides $1 million worth of coverage?
Only if the claim is deemed not to be covered by the patient's compensation fund. It's usually what the language in those policies says.
Okay, so the medical liability policies often provide $1 million worth of coverage, which may or may not apply to a given case.
The policy says if the cap is not found to be applying in a situation, we will cover up to $1 million.
Okay. Have you all undertaken any analysis of how competitive the medical liability policies are that are purchased by our doctors every day in Louisiana?
No.
Have you undertaken any actuarial analysis of whether the doctors are protected or treated fairly in a system where they have to pay 50% of their premium dollar for $100,000 of protection? In other words, they have to pay 50% of their premium dollar for $100,000 protection, and whereas the second half of their premium dollar buys $400,000 of protection. Any analysis of that?
That's not really our purview. I mean, the underlying is the responsibility of the competitive market in that area. We think competition is a good thing, and competition is the best thing to drive rates down.
Do we have competition? And I understand that you're not an insurance executive, but I understand also that you've been working with the medical liability system in Louisiana for 12 years. So your perspective is going to be potentially helpful, at least to this member of this committee. I'll say that. I can't speak to it.
We're seeing several kinds of competition now at the underlying and at our level, by the way. There are groups of physicians that are choosing to opt out of the act, that have become not qualified. They won't receive the benefit of the cap. They won't receive the benefit of the panel, and their liability will be unlimited. That's a new phenomena. I'm thinking that if it catches on, it could cause us a big headache down the road. But I also think that they're taking a whole lot of risk. The other kind of competition, the most aggressive and functional competition, is self-funding, self-insurance. Most all large hospitals self-insure or belong to a SIF, a self-insurance fund. Nursing homes the same way. They do not buy insurance on the marketplace for the underlying coverage. And analysis is done very often by those kinds of businesses to see whether or not it is more efficient.
In other words, self-insured versus buying liability.
Correct.
But my question, and I'd love your perspective if you have this information, how much competition is there in the liability insurance market in Louisiana for selling that first $100,000 worth of coverage?
There's
10 or 15 companies?
there's over 20, but that are admitted to write.
Is there one or two companies that control 50, 60, 70% of the market?
Yeah, Lamico is the largest coverage of medical malpractice for physicians.
And they control how much of the market? And this is ballpark, I understand.
I have no idea.
It's right at about 50%.
Because we're here today and you all are saying, look, we've got to protect doctors from excessive medical liability coverage costs. And that's
We're not
a
changing
valid
the
point.
underlying, though. I mean,
I understand.
The
I'm talking
underlying's
about the
good.
whole picture. And I think you all have some perspectives, again, that are helpful to this senator. My question is, how much profit are these medical liability insurers making in Louisiana? For example, they're paying $100 million worth of claims a year, and they're only taking in $102 million. They're just very thin margins, or are they paying out $200 million a year and they're taking in $700 million a year? What do you all know about
that? That's easily found out.
Okay.
Information. There are admitted carriers in Louisiana. Each admitted carrier has to file what we call a yellow book with the Department of Insurance, but I don't have that information.
Okay, so you're saying that the medical liability insurers in Louisiana are legally required to file a yellow book with Commissioner Donlin, the Commissioner of
The
Insurance?
domestic ones are.
Okay. Does that include Lamico or not? Yes. Okay. So, Commissioner, at one of these hearings, it might be helpful to have Commissioner Donlin so he can tell us, are the medical liability insurers overcharging, or they're just barely scraping by, or, I mean, is it possible that they're charging, $300 to pay $75 worth of claims, that type of issue?
I can tell you only about experiences in another market, but basically, if you charge too much, you will lose market share. If you don't charge enough, you won't be able to cover your claims. So what they do is they generally issue back dividends to their members. Lamico is a mutual company, so any profits they have are owned by their policyholders. I think in the last several years they've been making substantial dividend payments to their policyholders, and that's how they keep the equal part of their business from getting out of hand, from charging more than they should.
Okay, so Lamico is paying substantial dividends. In other words, from an outsider would say that they're making good profits.
I think you need to talk to them. I'm really not.
Okay.
I can't represent them.
Okay, and again, that's just part of this equation about let's protect the doctor, let's protect the patient, yeah, let's protect the doctors from having excessive premiums that they have to pay. So you really can't tell us what percentage of Lamico's gross income is paid out in claims and what their net income or their profit margins are?
No.
Okay, and Mr. Schnauder, can you
No, I
enlighten us?
don't have that information.
Okay, have you ever looked at that data to know how much they make in a year in Louisiana?
No. But I think we're off topic. This bill has nothing to do with the underlying.
Well,
I mean, really.
Well, but I think you said that we want to protect the doctors. In fact, I think Mr. Schnauder's comment was that we want to provide the best we can to the healthcare system. I think that was what Mr. Schnauder, did you say that? Did you make that comment, Mr. Schnauder?
Yes.
And I think part of my question is, do you perceive the mission of the Patient Compensation Fund, its primary mission is to take care of the healthcare system or to take care of victims of medical neglect?
When we're sworn in, we take an oath, and the oath says that we agree to represent no individual provider, that we promise to pay the claims of the fund and also to defend the fund. Now, those are two conflicting promises. So we have to make sure that we husband the money. We don't pay everything that's put in front of us. But by the time it gets to us, it's been well vetted. It's either been a judgment or a settlement, and we approve them all. And we are very proud of the care that we take for the future medicals of our patients, of our claimants. We cover lifetime benefits for those that need them due to the harm that is caused them by providers. And we do utilize the workers' comp fee schedule to come up with the cost of them. Sometimes they're not making everybody happy, but we have to have some basis to base our payments on. But those there are some people who will settle that. Whenever I have a workers' comp claimant come to me and ask me whether they should settle or not, I always read them the law. If you settle the claim, you settle. That's the last shot you're going to have. And I try to make sure that all of my friends and clients understand what they're doing when they make a settlement. Sometimes if I were advising claimants, I would tell them perhaps maybe they shouldn't settle their medicals.
Now, and you said that you pay 99% of claims. Obviously, you mean 99% of the claims where there's a settlement for $100,000 or a judgment.
Right.
Because what?
Oh, more than 99%. I mean, it was 1 out of 3,000, I think, that we've actually gone to court on.
Right. But again, that's not 99% of all claims. That's 99% of claims where either there's a settlement
over
or a judgment.
100,000. Remember, we only see the claims over 100,000. I have no idea what goes on below that level.
And the next question is, okay, and do you have any idea of what percentage of med-mal claims are paid out of the total amount that are made with the Commissioner of Administration?
About 11 or 12%.
11 or 12%. Would you agree with me that in a case of a catastrophic injury under the current system, the bulk or the primary part of the burden isn't carried by the system, it's carried by the patient and their family? Say someone suffers a $3 million medical loss. And we'll just say a small part of it is actually medical bills. A lot of it is a dad gets killed because of medical negligence and the family's lost $2 million worth of income. Would you agree that under the current system, the biggest part of that loss is borne by the patient's family as opposed to the compensation system?
The system that we deal with is the system that is under the current law. We don't make judgments as to whether or not it's right or fair. It's just what the law is. We identify the claims. We use statistics to tell us what's being paid for those kinds of claims. If they go over 500,000 minus the medicals and the judicial interest, then we cover them, and that's part of the settlement. It's a negotiation, as you know. In every tort suit situation is a negotiation. Finally, if it goes over that amount, majority of those cases are medical cases, and those medicals are covered over and above the cap. And so
Is it Dr. Cossie or Mr. Cossie?
no, it's lawyer Cossie.
Lawyer Cossie.
But it's
But to
Kosei.
get back to
It's
the
Kosei.
specific-
The people in Shreveport are Cossies. I wish I were related. They have money.
Well, I'm going to pronounce it the way you want me to. Kosei?
Kosei.
Mr. Kosei, again, the question is, if a dad dies due to medical negligence and his family loses $2 million worth of income, would you agree that the patient's family carries more of the burden than the patient compensation system?
That's one of the trade-offs that has been presented by the system. I don't defend that. And in fact, I think that group is taken care of to a lesser degree than the brain damaged child who doesn't settle their medicals. We will cover their medicals forever, but if that dad is dead and his income was a lot, $2 million a year, and we don't have many of those, by the way. Most of our claimants are non-earners. Most of them are either on disability or non-employed, because we have a lot of nursing home situations and people who are retired. But we have occasion of employed persons that go over the cap, and they do have a loss.
Okay, and I think my concise question was, in instances where a primary wage earner for the family dies due to medical neglect, in those cases it's the patient's family rather than the compensation system that bears the bulk of the burden. Is that true?
Oh, if it's over 500,000, yes.
Okay. And you made a reference to, look, we may have a doctor situation where we see lots of claims, and then we may talk to them about how much they have to pay into the system. I remember an instance years ago where I had a patient that was blinded by medical neglect of someone who was doing, I don't know that names is pertinent to what we're doing, but an eye surgeon that was doing almost assembly line eye surgery. And when I called the PCF to find out what information they had on this particular physician, they gave the statement to me, well, when I pull up his name on the computer, it, quote, lights up like a Christmas tree, unquote. And this is my question, and I said all that to say this. Is it true that if a physician has multiple complaints, even multiple sustained complaints, that information is not public information, is it?
No, it's not.
Okay. So the public doesn't necessarily know if there's a physician who's had multiple instances of neglect or injury, and they've been reported and claims have been filed. You all are not going to consider that public information, are you?
No, we're not. And once again, we're not a licensure body. That is the purview of the Louisiana Board of Medical Examiners. We're covering the claims over 500,000. We don't just make decisions based upon anything other than the losses that a physician incurs to the patient's compensation fund, and then if it goes over his payments in, then he has to make an additional payment. But whether that physician is a good physician or not, or qualified to practice medicine, is a decision made at the Board of Medical Examiners. But we don't have that expertise.
Thank you, Mr. Kase. Mr. Schneider. Thank you, Mr. Chairman.
Senator Luna for a question.
Gentlemen, we know that our cap in this state is $500,000. How does that compare to other states? How many states have caps that low or lower?
Well, I'll just take a stab at it. If you've seen a cap, you've seen a cap. They're different in each
That's not my
state.
question. How much-
Well,
how many-
I'm gonna answer your questions as best I can.
Okay, sir, well, hang on
There
a second.
are-
Let me interrupt
the-
you, please. My question is real pointed. How many states have a cap
know.
of $500,000 or lower?
The caps in other states are different from Louisiana's cap, was the point I was trying to make. Mississippi's cap is below $500,000, but it's only on non-economic damages. So in that regard, it's different, and it doesn't cover the economic damages that Mr. Senator Milkovich was addressing. Ours does.
All
There's
right,
a difference.
We got Mississippi at
And
lower.
Texas
Correct.
has a similar cap, and it's below 500,000. It's 500 or below, and it's once again on non-economic damages, and it moves depending on what kind of provider you are and whether you're public or private. Texas has a different system. All of the states have different systems. They're not apples and apples.
Are there more, if we're oranges, are there more apples than oranges?
I can't tell you that.
Well, I mean, do we have anybody that our system is similar to?
Well, we were most similar to Indiana when we started. We were identical, but we have diverged from the Indiana path in many regards. For example, they pay.
Anybody else other than Indiana that we're similar to?
Not really. We're pretty unique. There's only about 13 states that have funds such as us, and there's only about 9 of those that are viable. Many of them pay, once claims exceed, only on catastrophic injuries, they only pay once a claim is at $1 million or above. There's not a lot of states that are anywhere close to similar to us. No one pays future medical bills like we do. You know, there's been comments that the cap has never been increased since 1975. Well, that's not true. In 1984, the Supreme Court ruled that it was $500,000 plus all medical bills from the date of the injury. And that's a huge increase to the cap. All other systems don't have future medicals. They may pay $1 million.
When was that
but that
case?
includes medical.
When was that decision?
84.
1984.
So there's not been any increase since 1984?
Correct.
Instead of 1974?
That's correct.
Okay. The question where y'all talked about the percentage of cases that you pay being 99%, where there is are we talking about where there's a unanimous panel?
No, that's a different issue.
Okay, because y'all don't necessarily, you go try cases sometimes with unanimous panels, don't you?
And the majority of cases tried are tried by the healthcare provider and their underlying coverage. PCF, we don't try 5 cases a year, less than 5 cases a year, on average. Sometimes we don't try any in a year.
Okay, that's just the nature of you're not an insurance company.
Right.
Correct.
You're a claims paying service.
That's what we are. That's
Okay.
correct.
You know, and one of the things you talked about earlier, Mr. Snyder, because you and I knew each other from a previous life, LIGA, which is also a claims-paying organization. One of the things you talked about was the rates and the increase that was potential here. You know, we'd compared earlier automobile insurance rates in Louisiana and that kind of thing. Well, automobile insurance rates are based on what kind of car you drive and where you live and who drives it and all those kind of things. But at the PCF, when you're talking about increasing rates at 4.5% per enrollee, you're increasing the rates on a family practitioner just like you are on an orthopedic surgeon or a neurosurgeon.
Of course, the base is a lot lower.
Okay, well, let's answer my questions first, and then you can make your comments. Am I correct in that? You raise it across the board, don't you?
But if you use your analogy, if an insurance company came in and they had to raise everybody's auto insurance to a new level, it would be a flat amount across the board as well.
But that's not the way that works. The point I'm trying to make is you're comparing apples and oranges yourself. The real situation here is that the reason there's a 4.5% increase per enrollee is not, it's more related to the overall cost. It's not related to the exposure.
Correct.
So why can't we look at it to where we make it relate to the exposure? This bill is a very narrow group of doctors. I can't fathom how a dentist could fall into this category of this bill. You mentioned a dentist earlier, but I can't. I mean, unless he decided,
Anesthesia.
you know, maybe if they decided to do some kind of oral surgery that somehow they involve the brain in or the brain stem or something like that. But I mean, it would be the most extreme case I could imagine. I don't know how most of these physicians would fall into this category. I think this is an extremely small group of physicians we're talking about. Why, if the cost goes up, and these are very specialized doctors that make typically much more money than these other doctors, why would they not have to bear the cost of that if it were to come to fruition?
Well, the way, talking with the actuary, actuaries use statistical data and credible data over a long period of time. We don't have that data because we don't have this in place. His reasoning is we would have to put it across the board until such time, and he usually wants 8 years minimum, he likes 10, in order to then look back at the history to say, okay, you had 100 brain damage child cases. This is where these were the specialties of doctor, hospital, whatever, that caused them, so this is what their rates need to be.
Why can't we use empirical data from other states?
We do.
He uses that, but again, we're so much different. The hard part an actuary has with our system is the unlimited medical bills. We're still paying medical claims on a 1977 case. Well, when that physician enrolled in the fund, they paid an amount to 500,000 limit, period, the end. Well, in 1984, Supreme Court said, no, retroactively, you're going to pay all the medical bills. So that 1977 case all of a sudden became an exposure to us that we're still paying. Okay, so.
Still paying from 1984, from the case that was decided in 1984? Is that what you're saying?
Oh, yes.
Okay. You're not talking about that specific case. You're talking about currently what it is.
Currently.
So
yeah.
what you couched as the increase in 1984, we're still currently paying that.
Correct.
Okay. I understand that. I don't know what that has to do with this bill, but clearly we would still be bound by the cases that are there.
My point is the actuary can't, he has no guesswork. Usually on any insurance, you have a policy limit. So the actuary can say, okay, worst case scenario, this is what it's going to cost you.
And I understand that, but
with the
isn't
patient's
that
compensation fund, he can't give you that number because it's unlimited.
Okay, but doesn't the same scenario apply in a lot of other states and a lot of other instances, or like we talked about workers' comp earlier? It clearly applies in workers' comp.
But they have policy limits. We don't have a policy limit because we're not an insurance company with a policy. We pay unlimited future medicals. No matter what the law is, workers' comp, you pay medical bills till the person dies. But that's through an insurance policy that has a limit. So the actuary can say, that's what that limit costs.
Are you telling me that maybe we need to switch to an insurance system in Louisiana instead of having a PCF, so we can figure out what's the best practical way to do this?
That's your decision. We will be here as long as you want us.
But you limit the.
Well, I mean, is that a better
huge,
system?
That unlimited medical bills for patients such as Kai is precious. It is. Nowhere else in the country has that. So we are taking care of those injured claimants until they die.
Mr. Snyder, I'm not going to challenge you on that per se, but I'm telling you, I'm almost certain that there are other states that provide lifetime medicals for people that have been malpracticed on. Are you telling me I'm wrong with that?
I've never seen one.
Okay,
I'm not going to tell you you're wrong, but I've never seen one.
One of the other interesting things that you stated earlier when you were talking about most of your claimants with the PCF, and you said most of them were non-earners, has anybody ever looked to see if that's any kind of correlation with a level of competent care that they received, that poor people that don't have insurance and they get lesser doctors, they don't receive good care? Have we ever looked at anything like that?
We don't have any information on that. Oh, we do check when we analyze a claim as to whether someone's employed or whether they're not, and that's just that changes the whole
negotiation as to what the future damages will be, because you're including income then. I think it has to do with age more than anything. We run statistics on the age of the claimants, and a large portion of them are 5 years and under, and a very large portion are 60 years and older. That's because they have health problems, and you have the bad births and injuries at younger ages, sicknesses, illnesses, that,
Those are the ranges of ages where you need more health care.
correct.
Okay.
So the potential for malpractice is greater.
Well, you know, I think one of the things that we do incorrectly here in Louisiana is that we have no accountability for good doctors versus bad doctors, because we have doctors here who repeatedly commit malpractice, and we have doctors here who never commit malpractice. And until we address those issues and we look at these hard questions, I don't think we're ever going to solve this problem. Thank you, Mr. Chairman.
I just have a couple questions myself. A few minutes ago, and y'all may not be able to answer this, but it was discussed that Lamco sells $1 million policies whenever the doctor's only going to be on the hook for $100,000. Why would that be? Why would that be necessary?
Well, there were many years when there were active court cases that challenging the constitutionality of the cap, and they sold that policy as an additional opportunity of coverage for that doctor in case that case was lost and the cap was found to be unconstitutional.
And let's see, I had one other note. We talked about healthcare cost and how this could potentially change that. What percentage of healthcare cost is associated with attorneys' fees and premiums and things like that? Any idea on that?
It's in the single digits, small single digits, as far as the overall cost of healthcare.
All right, I think Senator Milkovich has one final question before we move on to the opposition.
I'll wait.
You wait? Okay. The board's clear. We
Thank
don't
you
have
for
any
the
more questions
opportunity
for you.
to come before you today. We look forward to working with you on mal issues.
We do have quite a few cards in opposition, although we only have one wishes to speak. Ms. Jennifer Murzak, we spoke about that the other day. I think I got it right. If you'd come to the table, and then while you're making your way down, I'm going to go ahead and read through those that are here in opposition but wish not to speak. Jeff Williams, Louisiana State Medical Society. Sabrina Noah, Louisiana State Medical Society. Wes Hadaway, Louisiana State Medical Society. Ms. Dinkler with Children's. Ryan Haney, Lamco. Chris Kohler, Adams and Reese. Stephen Guillory, Baton Rouge Area Chamber. Joe Donchis, LNHA. Dan Robin, Jim Harris, Coalition for Common Sense. Lemony Walker, Louisiana Nursing Home Association. Berkeley Durbin, Medicine, Louisiana. Greg Waddell, Louisiana Hospital Association. Mark Berger, Jennifer McMahon, Louisiana Hospital Association. Greg Cossin, Louisiana Chapter, American Academy of Pediatrics. Ronnie Duncan, FMOL Health System. Eddie Lowe, Louisiana Chapter, ACOG. Cindy Bishop. All right.
Mr. Chairman, members, Jennifer Marusak on behalf of the Louisiana State Medical Society. And let me start off by assuring you that this is the last place I want to be sitting right now. Secondly, I don't know if Senator Gatti, where he went, but I want to assure him and Mrs. Gatti that I and our team, which I know Senator Gatti met a couple of weeks ago, purposely made the decision to not ask our members to contact he and his office. So we did not do that. We were not the ones contacting his office. We have known from the beginning that he got elected of his family situation and knew that this type of legislation would be coming from Senator Gatti, and we understood that it would be coming because of his understanding of the situation. And so we respect him for bringing that and understand it while we still disagree with it. We understand it's not a perfect situation, and necessarily not a perfect system that we have. But yes, Senator Luna, we are the only state that pays all future medical costs, and so it does kind of muddy the waters when you're comparing apples to oranges to grapes, actually. And when we talk about not only the possible or the not possible, but the actual premium increases that would be coming, you know, you have to look at what else all of our providers, and not just the physicians, but the hospitals, the nurses, what's come to them in the last couple of years that's actually forced some of our providers and physicians in particular into early retirement, whether it's been the constant technology upgrades and investments that they've been forced into, the additional personnel investments because of the red tape that they've been forced into with Bayou Health, if they want to continue caring for the poorest of the poor in Bayou Health. The ICD investments and mandates through the Affordable Care Act, the medication expansion cost for those especially in private practice that are coming July 1st that we know. The tightrope that's already being walked through the private public partnerships for the state and the LSU system and our medical schools. Those premium increases, you know, we just know for the providers and the facilities involved would be detrimental to the healthcare system in our state. Because when we look at all those providers that we're asking to participate and continue to participate and actually grow to participate in Bayou Health and with the expansion of Medicaid, we're already having problems getting OBs to participate. I had some of my pediatricians call with concerns about simply treating children for concussions, that they're worried about their liability and how that would grow with this legislation. Of course, never mind to say the pediatric neurosurgeons that they would have the ultimate liability. But again, we just would like to voice our opposition to the legislation for the obvious reasons.
Senator Milkovich has a question.
Thank you, Mr. Chairman. And is it Jennifer Marusak?
Marusak.
Marusak.
Yes, sir.
And Senator Luna is helping me with the spelling.
He sees it
I
every
think
day.
Chairman Ward got it perfect the first time. He's a great chairman. He does a great job, doesn't
We
he?
practiced the other day together.
Okay.
The side.
He's very gracious to all sides, and we really appreciate his work so much. I'm going to very quickly reiterate, because this is a gut check day for us in this committee, what the Gatti family's been through, and really the light that their plight has shown, not just on what other families go through, but also on the system. And I thank you for what you bring to the table, because you're saying something very important for everyone in this room to hear, and really the state. Our doctors are not really the bad guys. The doctors nowadays, they're dealing with like you said, the Affordable Care Act, electronic records. That's a joy for some of them. The ICD code, that diagnostic code that's gone to 9,000 definitions, gone crazy. Their staff costs are going up. Some of them, I've heard over the last year, sometimes they don't get the respect that they deserve from the Louisiana State Medical Board. You don't have to say anything about that, but you know what I'm talking about. And on top of it all, ERISA, the federal law, used to be under state law that if there was a medical bill that was owed, you go to state court, go in front of the district judge, bang the gavel, 60 days, pay the medical bill, and pay the doctor's lawyer for having to come here. But now we have ERISA, which is a federal maze, and doctors sometimes have to have as big a staff trying to get medical bills paid as taking care of patients. And if I'm wrong on any of it, correct me.
No.
Our doctors are doing a heroic job fighting the bureaucracy, aren't they?
We're trying to.
They're trying to. And they are. And they're still, and I think I'll let the other members of this committee correct me if I'm wrong, but I believe it's the sense of this committee that our doctors are doing a heroic job. It's certainly the belief of this senator. But let me ask you this, because I'm curious about the extent to which the system, including the liability system, and we have dedicated professionals in the medical liability system, we have dedicated professionals with the PCF, but sometimes it seems like the system is pitting the patients versus the doctors when really they're on the same side. Do you agree with that?
Absolutely. I mean, the doctors are there for their patients. That's the whole reason they get into this profession.
I got it. But let me say this, and this may not get answered, and we're going to have to be really quick because we've got other things. But you may think about this, you may respond to it. Maybe we'll have a conversation in the hallway at some point in the future. But maybe how much profit is the medical liability industry making in Louisiana? In other words, are they making $20 million a year profit in Louisiana, $100 million?
I would have absolutely
Scores of
no
millions?
idea. More than me.
More than you, because do you agree with me that if the medical liability industry is making excessive profits, that means the doctors are being forced to pay excessive premiums? Would you agree with that?
I have no idea.
And if you can research that or find something out and bring that to this committee, that'd be great. And the other thing, very quickly, is do you have any idea, under the current system, how much the liability insurers pay to hire insurance defense counsel versus how much they pay to take care of patients? Do you have any idea of that breakdown?
And I don't have that information as well.
And I'll just ask you to keep an open mind to trying to find that out for information and sharing it with the members of this panel as we go
so they
forward.
have their own board. Limico and those companies have their own boards that I'm sure you could get to come speak to you when you request them to.
Okay. Thank you, ma'am. Thank you, Mr. Chairman.
Thank you, Senator.
Senator Luno has a question for you.
I appreciate you providing the information because I'm telling you, I thought there were other states that did it the way we did. But all the rest of the states, you just have to come in and prove up what your future damages are, and they're awarded to you
With their caps.
Yeah. What now? How many states have caps on the future medical care?
I don't know, but they would have. From what I understand, they would have their caps like your Blue Cross, policy.
It's my appreciation that I'm not aware of any other state that has a cap on future medical care. It is what it is, and you get it. You just get it up front instead of having it paid out like we do.
Well, but that's a guessing game then, right?
Well, then that's my point. Maybe
On
that's
what your
something else
future medical care would be.
Maybe that's something else we should look at
In
getting
other
away
states.
from, and actually looking at awarding those future damages instead of, if we can't determine what it is to set proper rates to charge doctors correctly, maybe we ought to look at changing that. So that's something for you guys to consider. Thank you.
Sure. Thank you, Senator.
All right, I think I have one question. I think we'll be done. Senator Milkovich just touched on this. Have premiums been raised since 1974? Have they gone up for doctors?
I don't know,
You have no
Senator.
idea?
I don't know. I don't have to pay them, so I don't.
Okay.
I'm not aware.
All right. Well, I think that's it. The board's clear now.
Thank you, members.
Senator Gatti, you want to close? Oh, one second. We do need to, and I believe you and Senator Martini got together on the amendments you had, and he proposed to where it says on Amendment 4 and in Amendment 5, catastrophic brain injury means any moderate or severe traumatic injury. We would add means any moderate or severe
Brain injury.
Traumatic brain injury.
And we believe that there might be somebody who says, oh, it's just traumatic injury. But we wanted to make sure everywhere that moderate or severe traumatic injury was in the definition, that brain was the organ that we were talking about, because we didn't want this to get outlandish in its scope. And I have no objection to those amendments. The staff and I worked on it.
We'll withdraw the first set of amendments and resubmit them with traumatic brain injury.
Thank you.
And I don't see any objections, so those amendments stand adopted. you can close.
Well, I just want to say, first of all, I want to thank Kai's family for coming. A lot of people could not make it because when you have a severe brain injured child who meets this narrow criteria, you don't leave the house much. So when he hears it's ready to drive, I'm sure he loves to get out of the house. And it's been nice to get to know his family. I did not know they were coming until about a day ago. And so if we could just thank them for being here. And I just want to do that. And your words were so eloquent. I know that you were limited in what you could talk about, but every word you said hit my heart deeply, and I appreciate you for coming. Kai, I appreciate your hard work and learning to walk too, man. That's a big deal. That is huge, and we're very proud of you. And if I happen to get to heaven and run into each other, introduce yourself to me. Remind me of this day so we can talk about this day, okay? We appreciate y'all so much. And big sister, wow, what an angel sent by God to work with your brother. And I can see your compassion and how you helped him out of here to go to the restroom so Mom could keep talking. And what a blessing y'all are to come down here and testify and walk up all these steps and go all these nooks and crannies to find this room. And we appreciate you for being here. My crystal ball is broken on a lot of the things that we talked about today. Insurance rates, ups or downs, I don't know that. I mean, I think we've done a lot of insurance reform since I was a baby that I've had to read when I was in law school, and none of it really reduced rates. There was promises of rate reductions, but businesses don't see it, people don't see it, and I want to give you just, I appreciate the unlimited medical payments under our current system, but if you can imagine to a family that's been through it, that's kind of a slap in the face. Just in this small reaction, because the lawyer has to explain to you that the hospital that hurt your child has unlimited resources to help pay for the medical care needed for the mistake they made. Unlimited. But you're limited to $500,000. So the reason that was put into the law is it was lobbied for and agreed with by the lobbyist for the healthcare industry, because they said this is kind of great because everybody pays into a fund that pays our doctors to fix the kids that are hurt. But we still want to keep the cap there. I'll tell you, Indiana wasn't a cut and paste. They've raised their cap to $1.25 million across the board, not just for catastrophic brain injuries. They're at $1.25 million. Indiana, I think that's where Notre Dame is. God, those guys figured it out before we did. And I don't see people struggling with that number in Indiana. But I will tell you this, my crystal ball is broken, like most of us have. It's just real broken when it comes to extrapolating or deriving underwriting behavior of insurance companies when this anomaly is placed on their desk. We do know it's probably going to go up. Because even if all the marginal practitioners left because they couldn't afford a higher policy, they would still find a way. And we heard testimony of this earlier. They're making doctors buy $1 million policy, and the Supreme Court has said the cap is constitutional. Now think about that. Senator Ward, if you were a doctor, I'm going to sell you $1 million policy, but the most per claim that you would ever have to pay is $100,000. Imagine that. And they want to tell me that I'm here advocating for my child and children like her, and that's going to raise rates. Well, heck, what's raised the rates is that you make somebody buy $1 million policy when they only need $100,000 in coverage. I have to take off my shoes and socks to count to 20, but even I can figure that out. If you make somebody buy $1 million in coverage when their worst case scenario is $100,000 per claim, that premium's going to be a little more for that $1 million policy than it is for the $100,000. Crystal ball's broken on that, but I do know this. $5 million for a family going through this might allow mom to stay at home and not go bankrupt, like we heard today. $5 million, I can't find anyone that would say a child's brain is worth less than that. Even when you ask the bean counters, they say a child's brain, if taken, and the pain and suffering and what they contribute to society, not even counting their loss of earnings, because you can't really calculate that with a child with an economist. Nobody says it's worth less than that. A lot of people say it's worth more than that. So I would ask that this committee allow this bill to be heard on the full Senate floor Because I will tell you this, Kai doesn't have a voice. Becca doesn't have a voice. Our first prayer, our first Bible study that we did was what? Lord, please help us be a voice for the voiceless. So we have several people that are voiceless on this issue, and we have some people that have not lacked a voice. When we talk about freedom of speech, it's an important thing, Senator Milkovich, very important. You know that. Rebecca can't talk. You know, Kai struggles. He'd love to come to this table, I'm sure, and talk about how he learned to walk from his brother and all that, but the speech portion of his brain doesn't work that good. A lot of people can't come here and talk today because after they went through this process and settled their case for less than $500,000, there was a gag order written into their settlement. So they can't come here because they're scared to death they'll get sued for civil damages for telling the story. But there's a group here whose freedom of speech has not been impeded. And they speak with money, and they speak in groups. Their freedom of speech has not been impeded at all. So we just have to decide who's the voice of the voiceless. And once we decide that, this becomes an easy bill to talk about. So I thank you for your time. I appreciate you giving me this day. I appreciate your kindness to my wife and my daughter. I appreciate your kindness to the people that came to speak. And I look forward to answering any questions if you have any more. Thank you very much.
We'll go off of what the pleasure of the committee is. There is a motion to move favorable by Senator Luno as amended. Is there any objection to that? Seeing no objection, the bill is moved favorably as amended.
Thank you. And I will have the data on the Senate floor of the questions you had. I will bring that data together so that the committee can make a full decision on that. Thank you.
Representative Gatti. If you're here on Representative James's bill with regard to, what's the number on it? 659, we're not going to hear that bill today. Senator Gatti, I'm sorry.
Okay.
And Representative James.
Some days I feel like a representative.
I feel like a dog catcher sometimes.
You got one coming. You know, scrapbooking. Thank you so much.
So
Yes, ma'am. Thank you.
you're going to do a presentation on these on the monitors? No?
No, we'll be quick.
Okay. Senator Gatti's going to hand out jump drives that has information relevant to his bill.
Yeah. Mr. Glenn, could you pass this out for me? Thank you.
Yes. Yes. I'll remind him.
Yeah, you sit there. She can sit there.
Okay.
Pull up a chair for Mr. Frugia.
That's good.
If you don't mind, Miss Smith.
You gonna sit with us the whole time?
Yes.
Okay, great.
Is our translator here yet?
Okay, good morning, everybody. We'll get started with SB 78. Go ahead, Senator Gatti.
Thank you, Mr. Chairman, members of this committee. My name is Senator Gatti, represent District 36, here today on Senate Bill 78. Senate Bill 78 is centered on my daughter, Rebecca. I have 4 daughters. My third daughter, Rebecca, was born on April the 25th of 2007. It was our third child. My wife and I are high school sweethearts. Went to LSU together, proposed to her at the bell tower. She's Baptist. I was Catholic, so we're Baptist. We compromised. And I just told her that we would have a whole bunch of kids. They'd all be saved. So we're pro-life. We're prolific. And that's my family in a nutshell. My daughter Elizabeth is here today. My daughter Rebecca and my wife Susan. My daughters Catherine and Charlotte are too high maintenance to be able to pack this quickly. So they're back in Bossier. But they're here in spirit. So let's talk about Rebecca's story. I was reading to Rebecca the night before she was born. It was kind of a tradition with our kids that we would read to them while they were in Susan's womb. And Rebecca responded to our voice. It was really neat. She was the first child we had everything ready for. We had our room painted, the crib together. With the first two, we were so young that, it was just tough to get everything together. We knew with Rebecca we'd have it all together, so we did. Susan went into the hospital with a little bit of high blood pressure, and the doctor induced labor. I received a phone call while I was at dance class with my 2 oldest kids. Called the mother-in-law, told her to come pick up the kids at dance, and then I rushed to the hospital. And things kind of progressed that night kind of eerily. There was a lot of confusion about what to do, and ultimately Susan was in great duress. Her blood pressure fell. Her womb tightened. It wouldn't relax. It was in a constant state of contraction. And there was kind of a debate between the doctor and the nurse what was really wrong. The doctor kind of thought, well, the monitor's just broken. The nurse thought there's something really wrong. And it took about 3 hours for them to decide to do a C-section. Later, we found out from a friend of ours that's a neonatal nurse at the Health Science Center that based on her reading of the fetal strip, what she thought happened was that when the doctor thought the external monitors were broken, he put on an internal monitor and more than likely put it on Susan's uterus or cervix rather than Rebecca's head. So we had a false reading for about 3 hours. That was a delicate time for Rebecca. She began to die. Her brain suffered a horrible hypoxic ischemic event that was avoidable. When they finally decided to bring in a bedside ultrasound because of Susan's demise, they put it on Susan's belly and it read 50 beats, which was totally opposite of the fetal heart strip. So they knew there was misplacement. In a typical situation, we found out we were at Dallas Children's that if there's an emergency situation, you can typically get a baby out in about 3.5 to 7 minutes, and that's the standard of care. It took about 28 minutes between the time they did the bedside ultrasound to get enough staff onto our floor to do a C-section. And so when Rebecca was actually out of the womb, she was dead. Susan was awake. She had local anesthetic during the C-section. So she saw Rebecca laying lifeless on the table next to her. Rebecca had, they do an APGAR score on babies when they're born, and typically there's 15 is what most kids have, or a 14. They test, different hospitals do it different ways, but it's typically color, breathing, and heart rate. They take those things, that's how they gauge a baby when they're born. Rebecca had 0, 0, 0 APGAR scores at 1, 5, 10, and 15 minutes. They continued to give her epinephrine. I was not in the room. They continued to give her epinephrine and woke her up. We found out later at Dallas Children's that not only did they kill Rebecca, but they shouldn't have brought her back. And as a dad who's pro-life, I said, come on now, that's kind of odd. We're all supposed to fight for life. And the guy at Dallas Children's told us when she was about 8 months old, he said, you'll be changing her diaper when she's 9. She'll have so many seizures, her hips will be out of socket. And I said, that's ridiculous. People with brain injuries don't suffer like that. So we had never seen, in all my years of practicing law and Susan being a PhD psychologist, we had never seen a child as bad as Rebecca, and Dallas Children's had not. I think it's because Susan was so healthy during her pregnancy, unlike me. I drank the ices, I ate the red meat so she didn't have to. I stood up to the plate, took a bruise for the team. She is very healthy based on her research as a psychologist. And so that's kind of what happened. As we began to think about it, we asked the doctor, what went wrong, and he explained to us that it was Susan's tilted uterus. It was probably a genetic problem. And so we had to go through some genetic testing on Rebecca, and we were kind of in the dark. Finally, I was at a thing called Pumpkin Night Light. It's something on Halloween public schools do where they carve jack-o'-lanterns and you walk down a trail. And this lady grabbed me and said, he's hurt some other kids. I said, ma'am, who are you? I'm standing there with my two oldest daughters. My wife's at home with Rebecca. And she said, he's done this before. I'm like, whoa, who are you? She was a nurse at the hospital who had heard our story. So that began us in a long journey of discovery. He told us that we probably shouldn't have any more kids because of Susan's biology. That was upsetting to us. And 6 months after, or a while after Rebecca was born, he was no longer with the hospital. His partner asked Susan to come back to the clinic because Susan had been at that clinic since she was a teenager. And I just asked one question to the partner. I said, can we have more kids? That's all I want to know. It's hard for us to even walk in this hospital after all we've been through. And he said, yeah, there's nothing wrong with y'all. Y'all can have more kids. So that was really the only time I really broke down, when this happened because, pro-life, prolific, I had to stand by my word. I wanted to make sure we could keep rolling. Well, we began to look at this, and as we met more and more families, like Riley, we met Kai and Jude about last month, and just sitting at Shriners, you meet folks, and when you have a child with a horrible brain injury, it only falls into two categories: a genetic disorder or a trauma at birth or right after. So we began to look at that and kind of putting the pieces together, and Susan and I began to advocate for that. Now, as part of our case, we had to go through litigation. Susan had to resign from her job at the Health Science Center as an associate professor. I basically decrescendoed my practice and took a job as a workers' comp judge, and so we put our life on hold. And as the case was going, we were told, look, you're not going to win. You're not going to win this case. It's hard to win the panel process. My friends told me that. Some judges told me that. And just said, look, just do the best you can for your child while she's here. And we thought she would pass away within the first 2 years based on her global brain injury. Well, as we began to search for answers, the lawyer called us one day and said, hey, we got the panel opinion back. And I said, well, look, I know we probably lost. He said, no, it was unanimous against the doctor. We rarely see these. And I said, well, explain that to him. He said, well, we picked a doctor, the doctor picked a doctor, and then the state picks a doctor to sit on a panel. They just look at the cold record, and they determine if he deviated from the standard of care. And I said, so he deviated from the standard of care? Yes. And then we said, okay, what does that mean? It means that your daughter's brain injury was caused by, not by your wife's tilted uterus, she doesn't have one of those, not by any genetic thing. It was he missed several opportunities to save your child's brain. And they were textbook, late decelerations, several hours before he decided to do the C-section. Well, so we got the lesson in forgiveness. We had to go through that. It was difficult to explain to my retired commander in the Navy, father-in-law, who watches more Fox News, I think, than O'Reilly, that his daughter's brain was worth $500,000. He saw the devastation Susan and I went through. He saw me warming up breast milk and feeding Rebecca like a baby bird. When we would go to church, he would be the one he would come to our house and watch. And this is a Vietnam veteran, naval officer, and then retired again from a great job as a vice president of a construction company. And he was completely befuddled that Rebecca's brain was valued in 1975 and 76 at $500,000. And so we kind of struggled through that. And so as I was on the campaign trail, more and more people became educated on the fact that a baby's brain is valued at $500,000 in the situation where they struggled through a birth injury that was avoidable. And so we began to talk to some other families and talk to some different people. And I explained to them that this bill won't change your situation at all. Many people, I want to be careful how I say this, because Susan and I were in a situation where we were fortunate enough that we didn't have to file bankruptcy when we won our case. Most people, when they win, file bankruptcy because it takes all your savings, everything you've got, all the favors you call in. It's a tough thing in these situations. So we began to talk to folks, and when the Oliver case came out a few years ago, we were all watching that case because this was a horrible case. I think it was a nurse case. A nurse had failed to diagnose cancer in a young child, and so that child went without treatment for about a year, and the child had a devastating life after that. The court said, yeah, that if the nurse would have caught it, wouldn't have been as much harm. And so, but the court said, emphatically, they said, basically, this is my version of what they said. They said, we're so tired of reviewing the constitutionality of the Malpractice Act. We're going to scream it from the rooftop this time. The legislature has the power to set the cap, not us. They have to do the balancing test. They have to balance the level of safety in the community with a value on a child's brain. And so they sent it loud and clear from the state Supreme Court that the cap is constitutional and that it is our duty as legislators to review that, like other states have done, and determine if the cap needs to go up, down, or changed. So this bill really focuses on the following. With broad strokes, the current medical malpractice procedure is this. You file a letter with the Patient's Compensation Fund. They impanel 3 doctors to look at the medical records and depositions. The panel makes a decision, unanimous either way, 2-1 either way, and then the plaintiff has a right to file suit in the district court where the harm happened, and then they move forward with their case. That's the procedure in broad strokes. What this bill does, and I'll tell you that the ultimate end result of that procedure is that if a jury comes back and says, hey, your child's brain and all you went through, that unanimous panel, we feel like a fair trade value of your child's brain is $7 million. Plus, that includes the pain and suffering, your wife's loss of earning capacity, whatever it is. And they say that's our fair trade value. Well, the judge then thanks the jury for doing their job. They leave the building, and he says, by law, I hereby reduce this award to $500,000 plus future medicals. So many families do not try these cases. Sometimes the cost of these cases eclipses what they're awarded. All right, because experts are very expensive. And so a lot of times, you know, we struggle through that with families who call us and say, hey, we got a huge verdict. Hey, we can make ends meet. And then, hey, no, you can't. You only get, you're reduced to $500,000, then you pay your cost out of that. So they're left with the residue of that. So what this bill says is real simple. It says, okay, Supreme Court, you told us we have to review this cap. You've told us in Oliver and Butler that it's okay to have 2 classes of people. You know, our Constitution says if you get full recovery if you get harmed. 2315 in the Civil Code says if you do harm, you've got to pay for it. We have 2 big exceptions to that rule, which is workers' comp and med-mal. In Oliver, they said it's okay to have 2 classes of people. You say, well, what are the 2 classes of people? I thought we had equal protection. Well, this is the exception because they allow the legislature to do a balancing test, is you have 2 classes of people. Let's say you go in to the hospital and they say you have cancer, or you have cancer, they misdiagnose it as a lump on your back. Let's say you go to a physical therapist, he says, oh, that's just a lump, we're going to work it out. Well, it happens to be a tumor in your muscle, all right? That's a misdiagnosis. Let's say you go to your doctor 2 weeks later. He says, oh, we caught it in time, and they cut it out. Well, that claim is probably worth $25,000 maybe because you just had a few weeks where you were scared to death and the cancer didn't spread. Well, you get to recover 100% of your harms and losses under the cap. Let's say your case is worth $490,000. You get to recover 100%. So that's the first class that recovers 100%. The second class is the people like my daughter Rebecca and Riley who suffer a traumatic, permanent, avoidable brain injury that affects every part of their life, and they get to argue about, are you going to get $500 or $475? We'll give you $475 because we only give $500 if you try your case. You see, that's the negotiation that happens in a catastrophic brain injury case with a child. So let's talk about what this bill really does and kind of get past the fears that have been shared with a lot of people. First of all, the bill only deals with one class of people. The class of people that it deals with are people who haven't reached their 18th birthday yet, children. We already set aside some things for children in like first-degree murder. If you murder somebody under a certain age, it's first-degree murder. So we children are our hope and our destiny and our future. We protect them. And so this is from fetus, a child in the womb, all the way up to 18th birthday. That's all it covers. Secondly, that child must suffer not a mild brain injury. There's 3 categories of brain injury. There's mild, moderate, and severe. So it has to be a moderate or severe brain injury. Moderate or severe brain injuries are objective findings on an MRI. Any judge or neuropsychologist can look at an MRI and say that's at least moderate, probably severe, without even seeing the patient. So it's the most extreme of the two. But there's a second phase to the injury that's real important. You have to have the brain injury, and the brain injury has to cause an orthopedic component, meaning that you have to have partial loss of use of one limb, which we see in a lot of cerebral palsy cases from birth. You have to have paraplegia or quadriplegia. So even if you have a moderate or severe brain injury, if there's not a component that affects you, your muscles, so to speak, then this bill would not help. So that's the category of people we really want to help, because they're the worst. They're the most catastrophic, and it's the most injustice for them to be valued, for their brains to be valued at $500,000. Secondly, the procedure has a wrinkle in it in the bill, and it's a very important wrinkle. And that wrinkle is when you file your letter with the PCF and the doctors are impaneled, you have to get a unanimous panel, which those of you who have studied this or sat on commissions before, you know it is a rarity for a plaintiff to get a unanimous panel. I think 12 to 14% of the claims that are actively accepted actually go in the plaintiff's favor. And I don't have the actual number on that. Maybe some of these other speakers do, of how many are actually unanimous for the plaintiff. So it's a narrow category and a very narrow group of people. And once again, the Supreme Court said we can do this. We can do this. So the difference would be is if a child under the age of 18 suffers a catastrophic brain injury, and there's a component of partial use of one limb, paraplegia or quadriplegia, then they would have to win their panel unanimously. And then if there's a settlement, that settlement would include up to $5 million. Now, in all honesty, I want to make it clear that if you take your child's case to trial and you get $15 million for harms and losses, you don't get $15 million. This is not an uncapped damage. The judge will dismiss the jury, and he'll say, I hereby reduce the verdict to $5 million. So it's a known risk. It's not unknown. I mean, we know there are possibly, on average, 4 of these cases a year, and it affects families, grandparents, aunts, uncles, the whole family. It affects a lot of people. And so that's what this bill does. So I want to didn't do this in Jude, but because I know y'all may not be familiar with this, but I handed you a document, and I want you to just kind of look at this document if you have it in front of you. This is a review panel opinion, all right? And on page 1 is the letter. It was to our lawyer offering the opinion. The second letter is from the fund. The third page is the opinion of the review panel. Now these are rare, so I wanted to show you what one looks like. On page 3, it says that we hereby find, and number 1, the evidence supports the conclusion that the defendant failed to comply with the appropriate standard of care charged in the complaint. That's the first finding the panel makes. Secondly, this is 3 doctors. 3 doctors on number 2 said, and they were all OBGYNs, they said the conduct complained of was a cause or factor in the resultant damages. Now, this is unanimous, and one of the doctors was picked by the defendant. Now, we've highly redacted this so you don't see his name, you don't know what hospital it is, and all those things. Third, these doctors made a unanimous finding that the plaintiff, which is Rebecca Gatti, my third daughter, suffered severe brain damage which resulted in a severe disability which is lifelong and irreversible. I met Ben Carson up in Shreveport. I showed it with my laptop when he was speaking somewhere. And I said, hey, I bought 10 of your books. Can I have 2 minutes? I flipped open my laptop and I said, "You see this MRI? Ben, you name the price. I need you to fix my daughter." He said, "You pray over this girl every day. She's an angel." So if he was on this panel, he'd agree with this. When we got to Dallas Children's, the first question they asked us in the ER one night is, "Did you have this baby in a hospital?" And I said, "Yeah, I did. We did. I didn't. My wife did. Yeah, we were there. We were in the hospital." So these things come up. Now, the rest of the opinion just kind of lays out the logic that our panels do. So the panel reads through every page of the record. They plow through it, they mull it over, they think about it, and then by the time their deadline comes around, they meet together, they meet over the phone or meet in person, and they make decisions. And what their decision was that, hey, there were a lot of telltale signs here to show that this fell below the standard of care. Now, the last 3 or 4 pages is where all the doctors had to sign off on it, okay? Now, I wanted to share this with you because most of y'all probably never seen a medical review panel. This is the ultimate end result of the medical malpractice cap. This is what my wife and I received in the mail. And when you receive something like that, most people think, wow, those plaintiffs must be jumping up and down. Woo! It was devastating to our family because we really hoped in the back of our mind that this would say there's nothing he could have done. They used the best technology. They had the best people. They had the best training. Mr. and Miss Gatti, we're so sorry, but there's nothing that could have been done. And in fact, we found out that there were several things that could have been done, and they weren't that complicated, and they were at the disposal of that hospital. So why the brain? People have asked me this, and I want to bring it up to y'all. Ryan, why does this on Senator Gatti? Why does this, or Representative Gatti, whatever they call me? Why does this? Why'd you focus on the brain? Why? I was going on a trip with my kids, and we stopped at, I think it was Love Field or somewhere, and we always try to buy National Geographic to read on the plane, and they dedicated an entire issue to the human brain. And as we went through this with my kids, it was kind of neat because, you know, when you ask a child what's a brain, they'll say, "Oh, that's how I can throw a curveball. My dad says I have good hand-eye coordination," or "That's how I memorize piano, my brain." And so kids see brains differently. And so when we talked, when kids ask us about Rebecca when we're at church or different places, "Hey, why is she so small? Why does she look so different?" And we say, "Well, you know, her brain's hurt." And then we ask them a question because, you know, they're struggling to piece it together. And they'll say, "What does your brain do?" And they kind of say some of the things that National Geographic said. So Senate Bill 78 is simply a reaction to the most recent Supreme Court case that said they don't want to hear constitutionality arguments anymore. They've said over the last 40 years that this situation is constitutional and that we as legislators have the obligation, responsibility, and the duty to review the medical malpractice cap like other states have done. So I thank you for your time. I'll answer any questions if you have them.
All right. Senator Johns has a question.
Thank you, Mr. Chairman, and Senator Gatti. Thank you and Susan for your courage and for sharing your story with us this morning. Tell me about Future Medical. You
Right.
brought up Future Medical. Tell me how that works and maybe I'm sure if anybody at this table understands how it works, it would be you. So
Thank you.
Could you walk
Sure.
our committee through Future Medical?
Sure. It's kind of ironic. In Rebecca's case, we settled her future medicals because her life expectancy was about two or 3 years. Now, she's 9 today, all right? But we had the means. We weren't going to wait in line for a van. We weren't going to wait in line for the state to approve her Keppra. You know, we were getting cutting-edge medicine for her seizures.
Can you explain that, though, what you mean by that?
What Keppra is? Or
No, what you're talking about when you have to wait in line.
Oh,
What-
yeah.
what
I was a
is that?
workers' comp judge for 2 years. That was one of my favorite side jobs. All right. When I used to watch paint dry, that was probably my favorite job, but comp would probably be second. And what we noticed is that the Patients Compensation Fund uses the workers' compensation schedule as their way of paying claims. Now, as a workers' compensation judge, I saw many times people that needed rotator cuff surgery, but it would never get approved under the schedule. So when I heard that Rebecca, I mean, you have to realize this too, there are no pediatric guidelines in workers' comp. All right, so if I had to ask them for a deviation from the standard in the schedule so we could go see a pediatric neurologist in Dallas, can you imagine just that? And when you lose 2 weeks with a child having seizures because they've built up a resistance to the medicine they're currently on, and you want to try baclofen instead of Keppra, or you want to do you want to go somewhere where they'll give you a higher dosage through an IV. I mean, you don't have, I mean, when she's having diarrhea and she's seizing so much her hips are out of socket, you really don't have time to go through the state and get approval. So we just made the decision just to get all this in our rearview mirror, you know. I mean, we have a lady that we pay to sit with her every day out of the house. You know, I think that would have been a struggle to get that approved. I think if we needed transportation for Rebecca, it would have been a struggle to get that approved. So, yeah, future medicals are great in theory, but what we find practically as we meet some of these families is that it's a very difficult, it's kind of like workers' comp on steroids. You know, it's a very narrow gate. Now, I think they do a great job with protecting the fund. They have an obligation to make sure, you know, claims are not paid frivolously. But I think by picking the workers' comp as the gate by which these things are approved, it's kind of it's not what it's cracked up to be, but it's not bad. So,
And I asked that question because in my earlier years when I was in the House, there was a particular med mal case in my old House district, and I followed it pretty closely. Eventually, the young person died. I think the young man actually grew to be 24, 25 years old. But at the time of his death, I think at that time, and I don't know if there's some bigger cases, at that time, I think it was one of the largest in the state, maybe the largest. And they had paid out something in the neighborhood of $12 million in future meds on that particular case. So I remember that number. So I think they even actually built a room on to their house to accommodate them to be able to keep the child, you know, in a safe and in a comfortable environment. So anyway, I'm just kind of was very curious, you know, how that worked. That's all I have, Mr. Chairman.
Senator Gatti, on future medicals, I know you pointed out the process by which you get approval for whatever that future medical might be. I have to assume that part of the cost is not necessarily just technically medical in nature, as much as it is having somebody as a caretaker for the normal everyday things you do in life.
Correct.
Does future medicals cover that type of care?
You know, we weren't. We didn't use it at all. I mean, we just settled that. I think for maybe I don't remember even the amount. You know, but we just wanted to. We did not want to be going through a process to get approval for Rebecca for different things. But I think Ms. Frugier may be able to speak to that more because she's actually going through those processes of getting stuff approved. So.
Okay. Go ahead, Ms. Frugier. I'll let you go forward, but we have some more questions, but so stay put for just a minute.
Hi, my name is Mona Frugier, and this is my grandson, Riley. Riley has quadriplegic cerebral palsy. And Riley's cerebral palsy is due to malpractice by the hospital he was born in. They neglected to see about the issues that my daughter was dealing with when she was in labor with him, and it got pushed aside, and Riley ended up being born not breathing. So his is with lack of oxygen to the brain.
Hypoxia. Did I don't know if you know all the details, but did this case go to a medical review panel? Was there a suit filed? All that kind of stuff.
Yes, it did.
Is
and
it the
the
same
hospital
scenario?
was found at fault. So we deal with PCF now.
Okay. Do you know what the panel voted at the medical review panel stage?
They voted that that the nurses were found at fault.
Okay. Was it unanimous?
Yes. Yes. It was.
Does does your grandson require, is it 24-hour day care?
Yes, it is. It's 24 hours a day care, and I am the one that sees about him all the time. I take care of him. I'm his caregiver.
Okay. Senator Appel.
Yeah, I was really curious, Senator Gatti, about a couple of things. In the bill, and you made this point, you say that the definition of a child is from a fetus in utero. I'm just curious how, I mean, I know very little about medicine other than what my wife has taught me because she was a nurse. I'm curious how, yours was a problem in delivery, and I can see the mechanical aspects of that. But what about a child that's just has a problem after 3 months or something, and how do you define when the doctor made a mistake?
Oh, you mean like a brain injury?
Yeah, to cause an injury that would develop into a brain injury at birth.
Well, I'll tell you, as technology gets better and better, I'll give you an example. A CT scan doesn't always show a brain bleed right when you have a trauma. So sometimes a CT scan 2 weeks out shows a brain bleed. But with a hypoxic ischemic event at birth, it's typically the gold standard to determine the child's brain injury is an MRI.
Right.
So,
Yeah, well,
yeah.
that's what I say. I understand the birth part because I've had a niece who had a problem. My daughter had a problem. We had to do an emergency C-section. I can remember what happened.
Yeah,
but that was at birth, but this covers all the way for 9 months.
Oh, okay, I see. So let me give you an example. We've met folks who take their baby in to a nurse at a quick care or whatnot, and she says, "Oh, they just have strep. Here's some antibiotic." But it's actually double pneumonia. All right? So that child goes home and asphyxiates, either throws up or swallows their phlegm, and it's a little bit, because with babies, their tummies are so small. And then it causes a hypoxic ischemic event, meaning...
No, but wait.
Yeah.
You're ahead of... What I'm talking about, that's post-birth. I'm talking about a mother who is pregnant, let's say, 3 months.
Oh, okay. Yeah.
And because your bill covers everything, from conception to birth, and I'm trying to figure out how you.
I think it would only apply to the times near birth. Yeah, that's the.
Then it says from a fetus in utero to birth. To let me get the words. I'm sorry.
Yeah, it's on page 2, line 28 and 29. It says, child to lose partial or total use of one limb or become paraplegic or quadriplegic. And child means a fetus in utero or any natural person under the age of 18 years. Yeah, we could limit that to...
I'm just curious. I mean, it seems to me it becomes very difficult to define what was the actual cause of a child having a brain injury at birth.
True.
That could have occurred because of anything. I don't know.
Well, and what we find, I guess, to answer your question the best, because it's really about causation, and causation is an opinion that the panel gives. So let's say someone feels like that because of something that happened, maybe a medicine a mom was given at 3 months, that when the doctor gave her that medicine, it had a known risk of affecting the fetus, and that when he gave the mom that medicine, the fetus suffered a lack of oxygen through the red blood cells of the mom. Okay, well, she has the burden of proving that.
Yeah,
she has the burden of filing the letter, finding an expert to say that. I think is it possible, of course, but if the panel would, as 3 doctors would decide whether or not the hypoxic ischemic event was caused by an event during the pregnancy. And once again, for this bill to apply, that child would have to have such a significant brain injury that they would have to read like our opinion. It would have to say, breach the standard of care unanimously, okay, that the injury was caused by the breach. And so it goes back into that narrow panel process. We have a whole bunch of people open the gate and go in, but very few make it to the other side. We're expecting 3 to 5 a year.
Do these legal processes, are they like an arbitration, or do they require a great deal of discovery, and how does the lawyers get paid? I just don't know how this works.
Sure.
I mean, in other words, you got a panel of 3 doctors. So
Correct.
do you present the case like you would present it to a judge?
What you my understanding is you each side writes a position paper, and they share it with the panel and the panel's attorney that's been appointed, and that.
So the
I really don't
research
know.
and the discovery
Yeah,
is
all
done
that.
by the panel, not by.
No, it's done by the people. So for instance, the attorney for the hospital could have taken my wife's deposition in the panel stage. He could have taken my deposition. I could have taken the doctor's deposition. We could have experts look at the medical records. It's really a trial by panel.
Right.
So it's similar
like
to
an
what-
arbitration.
It's similar to that, but it's not binding. You can still go to.
Senator Appel, I've presented 4 cases to the medical review panel just this past year.
Yeah, he's
So
probably
you
better than
present you can take depositions, you can gather up evidence, you can incorporate it in your memorandum to the panel. The panel each side picks somebody, the PCF picks a middle guy, and then they can come back with an opinion. In this case, this opinion came back 3-0.
No, I understand that. I
But
just
even
didn't
if
know
it
how
had
the
come back 3-0,
process worked.
even if it had come back 3-0 against him, he still has the right to file a lawsuit despite the findings of the medical review panel. So it's not binding arbitration. It's not binding at all. So you still have an opportunity to bring your
Cap is
lawsuit.
binding.
The cap is, yeah, it's that.
Yeah,
Yeah,
so
that's
even if
done.
he filed litigation, he would still be under the cap.
Yep.
Correct.
Regardless of what the
Now,
opinion came back.
One last question, and I'm going to quit. But it seems to me, I have friends that are doctors, not related to this field, obviously, but and they've told me over the years that there was some negotiations relatively recently in the last few years about caps in general, and between the doctors and the lawyers and all those involved. Are you aware of any history of that? I can't speak to it because I've heard it.
Well, I'll tell you, and I don't know, but I'm going to tell you what I've derived through different conversations is that there was a big push a few years ago before the Oliver case came out. And the talk was, we're going to agree on like Indiana did. Indiana, which we cut and pasted into our law, Indiana's law. Indiana went from 500,000 to 1.25, and their Republican-controlled Senate just bumped up their cap to like 1.68
And
for
that's
next
for
year.
all.
Yes, all of
everything.
them. All of them.
Yeah, well, that's what I had heard, that there was some discussions of that in general across the board, not just narrowly tailored to one.
Well, and that was
But
the thing.
I just didn't know what the status.
And Senator Pell, I think what happened is once our Supreme Court ruled the cap was constitutional, there was no reason to negotiate anymore to raise the cap. Because once the Supreme Court said this is constitutional and creating those 2 classes is still constitutional, the legislature did this balancing test and it's fine. So the pressure was kind of off, so to speak, to come up with a compromise before the court ruled. So once the court ruled, all the negotiations, I think, stopped. This bill has started those negotiations again, but quite frankly, you've been to a lot of arbitrations. I have too. I mean, this is something that this bill specifically for the few children each year that suffer the worst injury that you can suffer from.
But my last question was just a broad question, and that was, don't you think that it would be more appropriate instead of? I understand the significance of this problem, but there are other issues, medical issues that are still under that cap. Wouldn't it have been more appropriate to order a group of the competing sides to come up with negotiations on caps in general?
Well, I think that's always available, and I thought that was going on when I got elected.
Right.
But what I found was that all those negotiations stopped once the Supreme Court said it was constitutional. So it was kind of like saying, hey, I'm going to negotiate with you in good faith. Let's get this thing worked out. Oh, the court just ruled, we're done. Now, if the court would have said the cap was unconstitutional, I'm sure the other side would have stopped negotiations. So but the court did something very wise. They say, give to Caesar what is Caesar, give to God what is God's. I'm not giving you a yes or a no.
No, I understand.
They say, that our y'all's committee can decide the value of a child's brain, and that's what we're
I
stuck
recognize this is an extremely, besides the emotional side, it's an extremely complex issue because it
Very
does
complex.
involve substantial amounts of funds and insurance costs and other things. So we, it's a hard call.
It is a hard call, and when I found out this only happened to about 4 kids a year, from the testimony in Jude A, and you say, well, if all 4 of those get a unanimous panel, which would be unheard of,
Right.
then the maximum that could be recovered is $20 million. The PCF currently makes that much in interest every year on their over $1 billion in their account.
And you did take the states out of this, so any injuries that would occur under Medicaid or
I don't
mean,
think that amendment the amendment's on our website. It has not been
Oh, I thought we
offered.
adopted
I
that.
think there is some resistance to that from some of the opposition.
I see.
And so I wanted to hear what they had to say before we fought that fight, because they feel like, oh, well, I guess everybody's going to move to work for LSU now, and so I was like, well, that wasn't my intended.
Yeah,
that
no,
wasn't
I
my
understand.
intended consequence. So
I understand. Thank you very much.
Thank you, sir.
So, Senator Gatti, I guess I want to ask Ms. Frugier again. When something like this happens, do you have to make I'm assuming you have to make modifications to your home. I guess your daughter made those modifications.
We have not yet made modifications. None of that has been done yet.
Okay, but for wheelchair access, bathroom, all those kind.
None of that's been done yet.
Okay, but I
That's
mean,
PCF. We have not dealt with PCF with that yet. We're having issues with getting a new van right now.
okay, but the PCF has a process by which those things can be addressed.
Supposedly, like I said, we haven't yet addressed those, which it's getting to that point where it's time. He's getting to where he's a handful.
All right. And does the PCF cover the cost of the 24-hour?
Yes, we get,
Care?
Yeah, $7.45 an hour. $7.43, excuse me.
Okay, and the $7.43 an hour, is that that's the workers' comp schedule that you were mentioning earlier? Okay.
It's $7.43 an hour that the caregiver gets paid to watch the child. And the caregiver typically is the mom or the grandmom. So it's a family member. And we know from brain injury cases that when you rely on family, like I can't do Rebecca's physical therapy on her legs. I have to leave the room when the physical therapist comes over because I cannot watch that. I can't watch her scream. That's just dad. Dad kicks in. So in essence, only the parent's going to do it for $7.43 an hour. And a lot of folks
Because you can't find somebody at that hourly rate, I'm assuming.
we can't find somebody for more than that. So it's tough.
Okay. Senator Tarver and then Senator Hewitt.
How long have this cap been on for this particular situation, $500,000?
1975, so it went into effect 1976.
So it's been $500,000 in 1976?
Yes, sir.
Have not been increased at all?
No, sir. There was a time in 1984 where the Supreme Court ruled that medicals would be unlimited because, as medicine advances, babies like Riley and Rebecca are living longer, so the cost goes up. And so they said this will be unlimited medical. So it's $500,000 plus unlimited medical, and that was the change from the 76 decision of $500,000. But it's always been $500,000 in Louisiana.
Okay, thank you.
Yes, sir.
Senator Hewitt.
Thank you, Mr. Vice Chairman. Senator Gatti, first I'd like to thank you, and is it Ms. Frugier or Brugier?
Frugier.
Frugier, for coming, and Susan, and sharing your stories with us. And I'm going to ask you to forgive me for a few minutes because, this is the Finance Committee. And so part of my job and part of our job is to ask about the numbers. So I'm going to talk about the numbers, but I don't want you to perceive that as a lack of compassion.
No, ma'am. We understand.
So I'm a little bit confused about the fiscal notes because we actually have 2 fiscal notes online, right? One, from what I understand you're saying is that the original bill and the original fiscal note is what we should be looking at, which includes the state insurance and the state employees, that they'd all be part of the bill. Is that correct, Senator?
At the current stage of what we're talking about today, that is correct.
Okay. Okay, so the So what the fiscal note says, my reading on it, and I want to again ask you to make sure I'm understanding this correctly, is it explains in the expenditures section that the average total of all medical malpractice claims paid from fiscal year 12 through 14 was $13 million. Okay, so that would be using the $500,000 cap, because that's what's in place currently.
Yes, ma'am. And I think that's all medical malpractice claims, not just babies with brain injuries.
Okay. Well, that's a.
Well, maybe
I don't know.
Maybe
don't know that question.
Maybe I'm misspeaking on that.
Okay.
Well, let's just assume for the purposes of your question that the fiscal note's correct.
And we have someone from the fiscal office that we may ask to come to the table in a couple of minutes to help clarify what was built into his assumptions. But so, in my way of thinking, if you translate that from, and I understand that not everybody got the $500,000 cap, so there's a lot of assumptions in my numbers here. But if you just increased it tenfold, which is what we would be doing by raising the cap from $500,000 to $5 million, you could be talking about, a tenfold increase in the cost to the state. We're talking about $134 million potentially.
And Senator Hewitt, that is, we have a couple of levels here, and the reason I wanted to have the fiscal office discuss my amendment that took out all state and government entities, and that was because the state already enjoys a $500,000 limit on liability in all of their entities. I think that's correct.
Yeah, that's it.
Okay, and so it would not make sense for the state. So the state's liability, like DOTD, is equal to the med-mal cap. So during tort reform in the 90s, we gave the state some immunities and some caps, okay, to solve our budget crisis. So that people wouldn't be able to sue DOTD for a brain injury. They could get $500,000 plus some future expenses. So in discussion with the state, in discussion with some folks, I decided to offer an amendment that excluded the state in these cases, because then it would keep us on par with the immunity and caps the state already has. This would have been the only situation where the state could be sued for more than $500,000. And he says, well, how can you do that under equal protection? How can you treat a hospital here different from a hospital? And well, the Supreme Court has already said we can create different classes of people under the Medical Malpractice Act. The people that collect 100%, the people who collect pennies on the dollar. We just have to balance that out. So my amendment would be to take all of the burden off the state. And the testimony, I think, will be from the fiscal office, is that it would zero out the fiscal note. But the other day on another bill that is similar to this in health and welfare, the opposition stated strong opposition to creating the two. So I mean, I'm trying to
and
ultimately your committee will decide on the amendment and whether or not it's accepted or not. But I wanted to give opposition a chance to answer that question, because I'm not really sure what the basis is for not letting the state out. I mean, that's what most people do when they come to this committee, is they amend the state out.
Well, I wouldn't. I would beg to argue that that's what most people do, because I do agree with you that what's kind of good for one is good for all citizens in our state. And so, I do in general support that kind of philosophy, and I don't like amending the state out just to zero out a fiscal note to get it through the finance committee. So I'm not sure that I completely agree with that. Why don't we, I don't know if this would be the appropriate time, Mr. Chairman, to get some clarification from the fiscal office on the fiscal note, or if you'd prefer to do it in a different sequence.
Just a point of order, Mr. Chairman. Do you mind if we let Ms. Frugier finish her testimony so that she can leave with her grandson?
Yeah, and we have some more questions probably for you, and then we'll get the fiscal guys to come up and kind of go through the fiscal deal.
Thank you.
So, Ms. Frugier, why don't you go ahead and provide your testimony?
Okay, well, Riley, I think I went through the birth part as to what took place with him. Riley, was about 8 months old when we decided to get an attorney because we knew we needed help with him. And it took about 5 years for everything to go through and for everything to be settled. He ended up, by the time we finished paying all the medical bills and all of the stuff that Medicaid put out for him, he got about $180,000.
So I'm assuming you settled the case, or did you go to trial?
It didn't get to trial because the hospital wanted to settle out of court because they knew they were at fault.
Okay, and you were, I'm assuming, compensated in the amount of $500,000.
Yes.
And you retained, you did not settle, you still have the right to pursue future medical costs. I think that's what you were explaining.
Yeah.
So there were about $300 and something thousand in cost?
Plus the lawyer fee, with the lawyer fees and everything else included, yes.
Okay.
That's what it was.
And your medical costs from the time of this incident to the time that you got you're settled, Medicaid paid that?
Yeah, but we had to pay it all back.
And that was
Medicaid had to be paid back.
Okay.
Yeah. So, and by the way, we come from the city of Eunice.
And I represent Eunice.
Yes, sir.
Yes, ma'am.
Okay. Well, Riley, it's just like I said, I have to do everything for him, from getting him up in the morning. I'm up early, bright and early in the morning, trying to get all of his stuff taken care of, his clothes, his medications, getting him fed and getting his braces on, getting him his food and stuff ready for him, because he can't just eat when anybody else eats because he's been diagnosed with celiac disease.
Ma'am, are your medicines and braces and any ancillary medical services like therapy or any of those kinds of things, are those being paid for right now?
Yeah, they're being taken care of. Some of it by PCF and some of it Medicaid is paying for. So, yeah, it's just it's a long day. I mean, from early in the morning till time for him to go to bed, and I'm his main caregiver. I take care of him.
All right, that's a lifetime commitment.
Yes,
There's probably
it
no
is.
amount of money that can.
And he has his therapies. I mean, he has private therapies. He's got his OT, physical therapist, occupational therapist, speech therapist. Plus, he has it through school. He gets it through school also, which Medicaid, which I just found out that Medicaid is being billed for that through the school. I never knew that.
Okay, so PCF is not paying for that care.
Not the school part. They're paying the private part, but they're not paying the school part.
Okay. You have anything else you want to share with us before we let you go?
I'm just here to try to help support the kids that are, not like Riley, that are the ones that are being born into situations like him, is to try to make things better for these kids.
Okay, thank you for coming today. I know it was a long trip. Senator Allen, you have a question for the panel before she leaves?
Well, more for Ron, I guess.
Okay.
Why don't we does anybody else has any question for
No.
Ms. Frugier?
Ms. Frugier, thank you.
Mr. Frugier?
No, this is her attorney. He just want to say a few words.
Okay.
Morning, Senators. Pierre Gremillon. At this point, I'm just helping the Frugier and Riley with their future medical care, helping them get a new van, helping them update their equipment, and then we're in the process of working on home renovations. The reality here is a lot of the patients who are catastrophically brain injured, they're not aware of everything that the Patients' Compensation Fund can and should do. And so, really at this point, it's very important for everyone, and Senator Johns, I want to address his point, but it's very important to understand overall, what we have is a system of where the $500,000 of general damages is paid, that case is settled, and most patients and most clients, like Riley, end up as a future med claimant, meaning that the Patients' Compensation Fund has the legal obligation to pay for all future medical care and related benefits for Riley's entire life. And that's a typical situation.
With no cap.
With no cap, exactly. And so I will tell you, and this is very important, and Senator Johns brought up a great point. Overall, the Louisiana Patients' Compensation Fund, the Oversight Board, the Executive Director, Ken Schneider, they do a really great job. They really do. They reach out. They do a lot of stuff. Now, in Riley's case, we're just asking for a new van that's a better quality van, simply because part of the wrinkle in the PCF providing vans is that the relatives, the parents or grandparents in this case, they're responsible for all the out-of-pocket repairs to a van. So, if you buy a cheap van, you end up with more repairs. So that's the only thing there. But again, I would say the payment of future medical expenses by the PCF overall, they do an exceptional job. They really do.
And those costs would also include modifications to a home or a bathroom or hallways or access to the particular home?
Right, and just to be clear, I did not handle Riley's underlying medical malpractice case. I am just coming in as their attorney to help them to request the proper home modifications and pursue the process through the PCF. But Senator Johns made a very important point about a future med claimant who was, as I understand, being familiar with that case was a child who was brain damaged and remained on a ventilator for 27 years. And yes, the benefit of having $12 million paid out is huge. But there's one thing I want to point out in that although the PCF fulfills their obligation very well, that the timing of the parents or grandparents getting a lump sum of money for these catastrophic, again, I'm talking about the children that meet the criteria of this bill that's before this committee, the catastrophic brain-injured children, the timing of them getting the financial resources to pour into these kids is critical. And let me bring this home because I handled a case back in 1997. Mom's pregnant, fraternal twins. She goes to the hospital, and while she's at the hospital, she has a uterine rupture. The girl baby dies, the boy baby survives. We get the records, go through it. The medical review panel unanimously finds the hospital's at fault. They did not have the ultrasound tech or the equipment available for the doctor to make the diagnosis timely. So the baby boy is born brain damaged, profoundly brain damaged, spastic quad. Now, what's important is a couple of things. It was a unanimous medical malpractice opinion in that it was brain damage. He would fit within the definition of this bill. But what's important is he's catastrophically injured. His parents are trying to figure out how to care for him. Yes, they are able to try to do things, but these cases do not settle immediately. Okay, and so what happens is the doctors at Children's Hospital, the little boy who survived this malpractice is Casey. The doctors at Children's Hospital in New Orleans tells the mom, look, he's about 2.5 years old at this point, says, look, just take him home and love on him. We don't know how long he's going to live. He's never going to walk, never going to talk, and he's never going to feed himself. So I got many phone calls of this mother crying. Now, fortunately, in this case, and the reason I'm telling you this case that happened back in 1997, fortunately, we were able to get the case positioned because it was a unanimous opinion and settle the entire case. So we settled the entire case. So with those financial resources, Mom, who was a paralegal, quit her job and rendered full-time care. They built a therapy room in the back of the house. The horse that they would get this therapeutic horseback riding once a week, they bought the horse. They put a swimming pool in the house. So to get the financial resources early when the children are young, this child, Casey, was 3.5 years old. Remember, this is the kid that the doctor said, never going to walk, never going to talk, never going to feed himself. We're able to get some financial resources up front by settling the entire case, future medicals, general damages, everything. Builds the therapy room. Instead of him getting physical therapy and OT and speech 3 times a week, he got it twice a day. So the picture I'm painting is the mother and the father poured the therapies on this kid. He's 3.5 years old, poured the therapies and treatments on this kid. So what ends up happening is Casey is 19 years old now. So not only did he live very long, but what has happened is everything has changed. He's a black belt in karate. Okay. He's a motivational speaker. He goes around to elementary schools. He still walks a little bit funny. So he's black belt in karate, a motivational speaker. He's doing college-level work, schoolwork. His mother homeschooled him. And he certainly feeds himself. So the point of me saying this is, and what's important about this bill, that it affects a small class of potential plaintiffs, these children who have this catastrophic brain injury. And based on the statements made by the Patients' Compensation Fund, it's only four a year. And so what's critical is when you get a lump of financial resources initially, and you have well-to-do, very focused parents, you can make all the difference in the world. Casey is a black belt in karate. He's a motivational speaker. He's doing college level work. His entire trajectory of his life has changed. Why? Because it started early on. And one of the points of this bill is if you get a unanimous panel or unanimous verdict at trial, and you're able to get general damages in a substantial amount like this, the general damages are not, the family's not just going to sit around and just enjoy the general damage money. They're going to put it to work in caring for this child, traveling, doing whatever care. And the point is, and getting back to what Senator John says, the Patients' Compensation does a fantastic job, but they reimburse for conventional medical care. Some of the care that Casey had was acupuncture, the massage therapy. I remember asking for the pool, for the PCF to put the pool in, and they kind of, in another case, and they laughed. Well, of course, the PCF's not going to put a swimming pool in, but the aquatic therapy, these water therapies were important for this patient. So the point I'm making is not only is the raising the cap and getting this amount important, but when the parents or the grandparents have these resources, they can change everything for the patient. They really, at a young age, you can change everything. And so the point here is that, okay, as the PCF stated in their testimony in Jude A, that they may, if this bill were to pass, they may have to raise rates 4%. Okay. Well, if according to them that there was only 4 patients that would fit this criteria a year, we're talking 4 patients at $5 million apiece, that's $20 million. Their investment income alone would cover that. They would not even need to tap their claims reserve money because what they're making on investments would pay for that. But the reality here is that we're just asking for, in these very small class of patients, that they be given a chance. Not every patient is going to end up with this type of miraculous turnaround story like Casey. The kid who the doctors at Children's Hospital said, just bring him home. We don't know how long he's going to live. He's never going to walk, talk, or feed himself or anything. We're not going to have every case that's going to fit like that. Rebecca's case may not fit that, and it's not going to fit that. But what we're asking for, and an important part of this bill is, it gives them a chance. It just gives them a chance. If you're able to have such a clear liability case to where you get a unanimous opinion or unanimous verdict, that just to get a chance of those resources in the right hands with a motivated, as I say, mothers can perform miracles. I watched Casey's mother do it. And this is why, I'm here today to testify, have the privilege to testify before you. And so, again, in terms of paying the future medical bills, like you mentioned, Senator Johns, you're absolutely right. The fund, it's unlimited, it's uncapped. They do a fantastic job. But in these catastrophic brain-injured kids, there are therapies and treatments that are on the cutting edge that the PCF just doesn't pay for. And I think to give the parents or grandparents the opportunity to try everything possible to make their child better is really what we're talking about. So,
okay.
Again, thank you for the opportunity to speak.
Thank you for your testimony today.
Thank you.
Okay.
Thank you.
All right, Ms. Frugier, I think that no one else has questions for you. If you need to get
Thank you.
move on home. Senator Gatti, do you have anybody else that'll be testifying? If you're here for any other bill except this one, we will not hear it until after lunch. Because the committee members, we're going to take a break for lunch after this bill's over. What's that? Okay. Good morning. Good morning.
My name is Jim Click. I'm an attorney, also that does medical malpractice.
Okay, let me just interrupt you for 1 second because I think Senator Ale has a question.
Just a couple of questions
Sure.
for clarification, really I guess for Ryan, but either one of you. This future medicals, is that, that's paid, Ryan, if somebody sues or starts a lawsuit at this point in time, and there's a settlement 5 years down the road, the 5 year period of which the lawsuit is going on, do they backfill for, is it considered future medicals because they started at that time, or is that under the $500,000 cap?
I don't know the answer to that.
No, the future medical depends upon how much the future medical is. If the future medical in the general damage award is less than $500,000, then it's whatever it is, okay? If it's more than the general damage award and the future medical up to that point is more than, then whatever it is more than, it's not capped at that point.
So you get say that the claim is worth $500,000, and I've got $300,000 worth of medicals during that period of time while the suit was going on.
Correct.
What does he award?
He gets $800,000.
He gets $800,000.
Yes.
So they do cover the medical. So that is considered part of the future medicals. What is going on during the trial?
Correct.
Okay.
And
My next question, and this is just mainly my ignorance. I'm not an attorney, and I'm just trying to figure this out. Ryan, you said you settled your future medicals.
Correct.
So when you do that, you take, I guess, a lump sum payment?
Correct.
Okay. But the risk of the child living longer than anticipated, the risk of things changing into the future and getting worse, the risk of all of this
falls on us.
It falls on you.
Correct.
But there's no ability to revisit it or anything else. Once that settlement's done, you're assuming, by taking that amount of money, you're assuming the risk into the future of what the medicals will be.
Correct.
No,
Correct.
No crawback, no nothing.
No, sir. And that happens in every case. When, like an 18-wheeler case, if you got hit by an 18-wheeler, there's no crystal ball. You hire a life care planner to look at the value of your medical care, extrapolate it out with inflation and what's more probable than not standard of what you would need to get through the rest of your life. And if that number is $6 million or $600, and that's what the jury awards, or that's what you sign on the dotted line. If it's $900, you eat the $300. If it's $200, then there's a gain to your family of $400. So it's a risk on both sides, but it gives you finality. What we wanted in our situation was we did not want to have to go before any board and argue whether our daughter needed a Keppra versus baclofen. We wanted that to be in our favor, and because Susan and I were financially able to do it, we could calculate that risk and take some of our investments coupled with what we settled for and hire a nanny that had 25 years experience with terminally ill kids, and she didn't go work for $7.34. Miss Kathy's worth more than what I pay her,
Hope she's not listening.
Yeah, she's listening. She's watching. She's been texting me, so I got to be careful. She loves me, and she's the best person in the world, by the way, too. But she has 25 years working with terminally ill kids for the state and 10 years working with kids like Rebecca. So, when you have those opportunities come up, you can't say, hey, will you take $7.23 an hour?
Yeah, no, I was just wondering, I'm trying to wrap my head around who assumes the risk after you make are they contingent settlements that you?
I mean, we
really?
didn't.
No?
I mean, it's
a any or all type of deal.
I'll tell you what we went through, Senator Lyon, because I want you to know it's kind of important. We were told Rebecca probably wouldn't live a couple of years, and we had suffered so many financial damages because of this. I just said, look, let's just get this behind me. Whatever they'll take, whatever they'll pay, don't negotiate too much. We were going to Dallas Children's. We were thinking about going to Phoenix. I mean, we were really in a time where I could care. I mean, you're gonna get $500,000 plus medicals for your kid's brain and negotiate over the future medicals. I said, come on, let's just get this over with, because I could borrow somebody's plane and go to Phoenix. I didn't need to get the PCF. I'm not like Riley's grandma. I don't mean that in a bad way.
Right.
But I wasn't going to put my wife in a situation where she would have to beg for baclofen, which is off the chart on the workers' comp guidelines. We just go pay for it at Walgreens. You know?
I just was wondering who assumes the risk, and you answered my question.
No doubt it's the parent. And that's why so many parents who go through this, they never settle their medicals because there's the huge fear factor. And what if we get $2 million and put it in a medical savings account, and then that runs out before they die? And if they don't die before the money runs out, we're stuck. And then technically they start using Medicaid, which is the burden of the state.
Yep.
So what we decided to do was just basically, we met with our families, we made the decision that was best for our emotional and financial situation to put this behind us. I don't know how many people settle their future medicals. I don't know how many people stay on the pseudo workers' comp system that there is, and that's why I don't know the answer to that question. So I appreciate your question.
Yeah. Again, we applaud you for you and Susan's bravery.
Thank you, Senator.
Yes, sir.
Yes, Senator. My name is Jim Click, and I've been asked here. We hope to have Professor Caples to come here today. He has done investigation, and there's a report that he did. It's part of the materials. It's actually the first part of your materials. It's not in the blue binder, but in the big materials that he gave you. There's a whole report where he addresses a lot of the economic issues. But what I've decided here to do today, and I'm an attorney, I'm going to try to be a little bit of an economist. I'd like you to look at the number 1 tab. And the thing that strikes you is that the number of medical malpractice claims have dropped dramatically since 2001. You can see it's almost a 50% decrease. The filings of claims have gone down from almost 3,000 to approximately 1,400. So there's no big boost of medical malpractice claims. You look at the next tab. This shows the full enrollees of the Patient's Compensation Fund over that same period of time. And you can see that the number of enrollees has dramatically increased. It's gone from, in the year 2000, we have approximately 14,000 enrollees. And the year 15,000, last time they took it, it's up to 23,000. That's about a 65% increase in total enrollees in the Patient's Compensation Fund.
Okay, but that's due in part to the fact that we've expanded who could become a member, right?
Right. Okay. And that has increased the number
Total
of people
revenue
that can take any kind of increase. Now, let's look at the surcharges, which is the next thing. In the last 5 years, surcharges for physicians have dropped between 32% and 45%.
Can you explain to the committee what a surcharge is?
The surcharge is what the PCF charges.
Oh, just the regular premium part.
Right, it's the premium of the PCF. See, this bill would only affect the PCF, all right? They already have Lamico. Lamico's charges also have been going down too, but that's separate. PCF here, last 5 years, their surcharges for physicians have gone down between 32% and 45%, okay? And that's because you've got an increased number of people.
And members, just to make sure everybody understands that when you it's like a premium on an insurance policy. I know it's not exactly the same thing, but it's something that you pay on an annual basis to become a member of PCF to get the protection of the PCF.
Exactly. And then here I have is the tag 4 is the last annual report, and this is just a letter that goes to various representatives. And it talks about the actuarial liabilities. They took a look at the total actuarial liabilities of the PCF as they existed at the end of the year in 2014, and they said it was approximately $756 million. They have in assets at that time over $900 million. Okay? So they had an excess of approximately $144 million. It explains, so they have this surplus of $144 million. That's in 2015. You want to know how they do it, okay? You look at the next page. total income that they got from filing fees and surcharges was 172 million, or 173 million closer. They had 20 million in interest that they earned. They paid out everything, claims, administration, everything like that, $125 million, okay? And so they had 193 million, they paid out 125 million, so they had approximately 68 million in surplus for that year alone, okay? And if you look at my last page,
I'm assuming that's why their premiums have gone down.
at the same time premiums are going down, they have been able to build up. And if you look at the next tab, you'll see that their surplus has gone up. Their assets have gone up every year at the same time. The premiums have gone down. Liabilities have remained very stagnant, in fact, actually dropped in 2015 by approximately 22 million. Their surplus has gone up, and if you look at note number 3, the last report from the PCF, March 2016, their assets now stand at over $1 billion. So from the time that last report, $900 million, $1 billion, they now have a surplus of close to $250 million. And this bill, they've talked about this, the interest payment alone could take care of the maximum recovery that you could see. You're setting a maximum for what these parents are going through. A jury could decide much less, but the maximum could be covered just by their interest. And unless there's some questions, I'm trying to be short and sweet.
No, I understand, and we appreciate it, but we need to stick around because we have a few questions. Senator Appel.
Thank you. I'm doing a little bit different math in my head. My math is interesting to me. We're talking about a cap currently at $500,000. What would you say a lawyer's, contingency fee on that be? 40% if it went to hearing?
Yes.
What would a lawyer get, about 40%?
Yes.
So that's $200,000. If we kick it up to $5 million and we stick with the same 40%, that's $2 million. Now, do you think lawyers are going to do that much less work, or that much more work for that change?
Well, the risk involved in these cases when you take
But you were taking the case at $200,000.
Right.
So now you're going to get 10 times that much fee, and it's the same risk, and presumably, there's also a degree of care that you're supposed to provide to your client. Presumably, you're going to do the same amount of work, whether it's a $500,000 cap or a $5 million cap.
Correct.
But your fee goes up 10 times. Is that... Why wouldn't the fee be proportionate to the amount of money the person recovers? In other words, the amount of work necessary for the person to recover.
Because there are risks involved, and then many times these cases end up being a zero. We end up getting nothing.
But you would have done that at $500,000. You have the same risk. So you're going to deny, today, lawyers are going to deny people legal services because the risk is there?
That's the reason why that we take these cases, is so that we can, these people are so badly hurt.
I understand that. But the money's not going to the people, the money's going to the lawyers.
It also puts in, instead of putting in $100,000 or less into their pockets, at the end of the day, after expenses and all that, it's going to put in close to $3 million in their pockets.
Right.
And they're going to be
and
able
the lawyer's going to get $1.8 million more for doing the exact amount of work that they did for a $500,000 cap. To me, I'm just curious. That's my math.
Well, you do that math, yes.
I'm assuming for a $5 million case, there'll be you would be more willing to invest in experts and what have you.
I'll just say this, because I do brain injury cases, and I will tell you the last brain injury case that I had to handle for someone that looked like you and I,
Sure.
that was hit by an 18-wheeler. We took depositions all over Texas of experts. We had to take every
You
doctor.
wouldn't have done that at the $500,000 cap?
Well, that's the whole point. You do it at the $500,000 cap,
Okay.
and that costs so much money that sometimes I sit people down from my church that come to talk to me, and they have a $200,000 medical malpractice case. I'll say, it's going to cost us so much money in cost. We talked about future medicals. We've talked about the
Now, you're talking about cost in excess of the 40%?
Yes. I mean, depositions,
so that's just
filing fees, experts to fly in from Maryland because no one in my community will testify
And you
against
wouldn't
the
have
doctor.
done that at $500,000 cap
Do
as
it
a
at
good
five.
practicing lawyer?
We do it.
But so that's the same amount of money at the $500,000 level. Now all of a sudden we're going to jump it to $5 million. Those costs are fixed because that's the same cost you were
I
going to
see
do
what
at
you're saying.
$500,000.
Let me
but
give you
the fee for the lawyer goes up 10 times.
Let me give you a proportion of scale. You spend that money on cases that you don't win, that are obvious malpractice. My friends that do this kind of work, they may do hundreds of these and only win a small percentage of them. But you have to spend the same money on each one. So you're right. I mean, we've
been doing this for how many decades? And there seems to be no dearth of lawyers willing to take those cases.
Well, I'll tell you what we see in malpractice and workers' comp.
Yeah.
You can't find lawyers to take those kind of cases. That there's very few people that take those kind of cases because the risk is high, the cost is high, and the likelihood of recovery, even if you win, is low. So,
But I guess my problem is the money's not going in the pockets of the people like that lady that was here. The money's going in the pockets of the lawyers.
Well,
large chunks of this money.
And I tell you,
and the lawyers doing the same amount of work, whether it's a $500,000 case or a $5 million case.
I'm going to tell you, Senator, I had no problem paying my attorney the fee that he earned.
I understand.
I did not
No, I
flinch
understand,
at it.
and I have no problem
He sat
paying
me down
a fair fee. But when we're on these
after he-
contingencies and you're just multiplying the size of the fee.
Well, I will tell you that sometimes the defense attorney representing the hospital receives much more. His firm
I don't
receives,
doubt that.
Because you've had to
I
pay
don't
defense
doubt that.
attorneys
I'm
before.
not I'm not disagreeing with you.
Think about if this went through arbitration, how many years I would have had to sit with my daughter, and they just kind of hope she dies because when she dies, the value
I'm
goes
just
down.
wondering if if this is the wrong approach. If we shouldn't be talking about some kind of no fault coverage rather than this procedure. I mean, if the end game is to get the money into the pocket of the injured family,
correct?
Not the party, but the family,
correct?
Then it seems to me we're going about this the wrong way because most big chunks of the money are going straight to lawyer fees and other costs. It seems to me we should be talking about a no-fault system where if it's a clear problem, that's it.
So
It's over.
you'd be for if you got in a unanimous panel, the family would get the value of the life care plan and whatever the jury awarded, whether it's $2 million or $50 million.
If you can eliminate a lot of the legal fees out of it, I think there'd be some model like that you could do. But my whole point is this. I just don't see, I would almost be willing to put some kind of amendment, I know you can't do it, to limit legal fees in these cases. To me, if the lawyer's getting paid X number of dollars at $500,000 cap, and it's going to be 10 times that at the $5 million cap, I just don't think it's fair to the families. And I don't know how to do that.
Well,
but
I'll tell
I'm
you
just
what.
telling you the way I feel.
Here's the problem: that if I go to the hospital in my area and say the most you can spend in defending a $5 million case is X, they're not going to be able to defend themselves if we start capping attorney's fees. Now, if you cap both sides and you say, look, the most y'all can spend on this traumatic brain injury case is $50,000 a piece. That's your fee, a flat fee. Well, nobody's going to defend the hospital. You see, and you can't let a hospital have unlimited.
The gentleman just pointed out there's a substantial surplus in the funds, and they have more than enough to cover their defense.
But I agree with your point that it is.
I just think this is, and I'm not pointing at your bill. I'm just talking more in general.
Correct.
But when you start talking about massive increases in legal fees that don't go to the family, and yet, in my mind, it's the same amount of work, to give, quality service. I don't get it, but that's just me.
Does go to the families.
Yeah, but you're right. If that's something you and I can work on, I'd be glad to work with you on that, because you've had concerns with that before, and we've shared those concerns. And this cost is outrageous, and I have to work in the confines of the Malpractice Act.
No, I understand
with this bill.
I'm not necessarily pointing a finger at your bill. I'm just pointing out a simple mathematical fact.
Thank you.
Thank you, sir.
If there's no more questions.
Okay, no further questions.
All right. Thank you. Just have my wife real quick.
Sure. Yeah, have her come up, please. Susan?
Sorry, Susan. That's the only way she doesn't cry. So.
You guys are kind of long-winded, so I'm going to bring her on. She's not no.
Welcome to the committee, Ms. Gatti.
And I'm Susan Gatti, privileged to be wife to this man next to me and daughter to the Rebecca in my arms.
That was not in the notes. She just made that up. So.
I guess I'm here to speak. I think oftentimes we're going into global things here, but I'm here to speak specifically to the pediatric neurological injury component for a child. Sorry. Yeah. It's been a long morning. As a psychologist and an attorney, I think we were unique in the fact that we were victims as well. So when you have a child, especially a baby that's injured, the first year of life is so critical and so unknown. Before we're psychologists and attorneys, we're Christians. So we believed in all kinds of miracles and all kinds of things that could happen, and we believed our faith was greater than a mustard seed. And I've also said many times that, your faith and your prayers are great for things whenever you pray for healing, and there's a lot of reward that comes when those prayers are answered. But there's a greater faith that comes from knowing that you want these things for your child and you want these things for your family, and they're not given to you for a greater purpose. So I believe that maybe she's here today to help whoever is watching in this panel see the greater purpose that can come from her life. Now, within the first year, knowing the power of prayer, that superseded my knowledge as a psychologist, if that makes sense. So you spend the first year of your life watching and waiting as you watch your child grow, and you watch for the smile to come, you watch for a roll to come, all those little landmarks that parents love to see, the first of everything when everybody takes the pictures. For my child, I never really got a first. She has a developmental level of less than a 1-month-old because she cannot even smile. But as you're doing these things, I think I had to leave my job as an assistant professor at LSU Health Sciences Center. Ryan then needed to leave his job as a practicing attorney, which he had worked years to establish, to become a workers' comp judge solely for the insurance, because my job was what had provided the insurance prior to this time. But I could not, in good faith, leave my child with my parents for an extended period whenever I traveled to DeSoto Parish and do these different things for grants for Department of Education, because I did not want to be an hour away if a seizure happened or if anything happened. I needed to be there immediately. So we made all these sacrifices because that's what you do when you're a parent. You sacrifice for your child. And I'm deviating greatly just because of the things. So during this first year, even though he is an attorney and I'm a psychologist, your demands and your focus are so completely on your child that really, even with our resources and with our education, we needed to have an attorney to navigate that process, because it's too litigious, it's too detailed, we don't want to see depositions. Like, I still haven't read whatever is in front of you from the medical review panel because I don't like to see those things. So that we could just focus on her. So while what is in place currently provides for their medical care potentially for life, it does not really provide for those kinds of things and those kind of sacrifices that families do make for these children that happen as a result of these things. Rebecca now is 9 years old. We have been told, just so you know the extent of her injury is great. And like, I believe Ryan kind of stole a few of my lines, because the best way I can say is when your brain is hurt, everything is hurt. So I think that's why this is such a unique thing for a child with a brain injury, is you watch these things go, because you never really know what's going to come of these things. So her current, you could give her any kind of list of diagnoses that you want. She has Lennox-Gastaut syndrome, which basically means she has epilepsy with a failed list of medications that exceeds anything, because nothing works, because she continues to have seizures regardless of the medications that she receives. For example, one of her medications, because we always have to try the latest and greatest because nothing works for her, one of her medications costs in excess of $1,000 a month. That's one of her 4 seizure medications. And by the way, Ryan, baclofen is a muscle relaxant, not a seizure medication. Keppra is on the failed medication list. But so she does have the seizures, which are a great cause of concern. Also, many of you come and try to look at her, which is nice, but she does have cortical blindness. So she is unable to see you, but her hearing is in perfect condition. That's why when she hears different voices, she will change her demeanor and listen to you. She has all kinds of, I could go on about the medical conditions. The greatest thing is if you look at her, she almost looks like a question mark at this point. We've gotten to the point where we cannot even make her comfortable because of her hypertonic. Her muscles become so tight and so flexed that there's no way to help her with that. There's no medication, there's no surgery, there's nothing that you can do. And as a result of those muscles staying in such a contorted way, it then twists her skeletal system as well. So when you look at her, she's pretty much in an arched back position, and the only way I've been able to keep her comfortable since birth is to have her past a 90-degree angle to be able to keep her comfortable at all. So we're now at a point where I cannot even get her comfortable for many periods, but it's always been the point with caring for her to put her in a good position to do things that are good for her. Long-term care puts her in short-term duress and pain. So it's always an ongoing battle as a parent. So to try to find someone to care for your child, to do those things, this is why so many parents lose their positions and they stop working and they find grandparents and they find parents to care for these children, because I can still remember the day, Miss Kathy, if you're watching, that you came to me, and that's a story that I could tell many of you longer, that's God ordained. I remember telling her I just want someone who would love my child, because a brain injured child, many people would look at me and say, oh, I've had my baby had colic too. A brain injured child is not a colic baby. A brain injured child is like a colic baby on steroids, because they scream all the time. So you just want someone to love your child. So you make all those sacrifices to do all of those things. And you do it willingly, and you don't begrudge it. And I really didn't want there to be a fault for this. I didn't want the money. I wanted to know that everything that could have been done for her had been done for her. But with those decisions that I have to make, for example, as she sits in a chair here crying, and I apologize for that, if I don't leave her in that chair for a certain amount of time a day, her muscular position gets too bad and it worsens. So oftentimes I feel like I'm looked at like a heartless parent, like, why aren't you doing something for your child? When in fact there's really nothing that can be done to help her, which is hard. She's even been described by one physician, by one pediatric neurologist, as having a less than 0% quality of life, because basically what happened with Rebecca is she's so injured that your body kills off what it doesn't need first for your brain activity, right? So it reserves your breathing, your heart rate, but another thing it reserves is your ability to feel pain. So while she's unable to do a lot of these things, she does feel pain. So, and like, there's no amount that can compensate for those kinds of things, but I guess I want to give an understanding to this committee that the burdens of caring for a child are so much more than the financial part of it. There's behavioral parts, there's social parts. We go on vacations and we're not really able to take her. We don't take her to restaurants if we can help it. We don't do a lot of different things, mainly because she doesn't like it. The fact that she's here and has been here twice is very rare for her, because she likes to be where she knows. And the best way we can say whether or not she likes something is whether or not she's basically quiet. She likes me better. So I wanted to say a few things, and I'm going to lose my notes here. you know, there's, so socially, she's not, when we go places without her, I feel like our family's incomplete. When we go places with her, I feel like it's too much of a burden for our family to carry. Emotionally, spiritually, all these different things happen, but I think the fiscal matter is mainly brought up just because it helps to ease these other things, because I think one of the highest divorce rates that you'll see in families are families of children with special needs, because the stress that comes with caring for a special needs child is so great. Trying to see what else. I think, and it's ongoing. It never really ends. I thought it ironic that yesterday my kindergartner woke up next to Rebecca, and she looked at me and she said, "Mom, will Rebecca ever get better?" And I had to look after 9 years of this and still look at my kindergartner and say, "No, you know, not this side of heaven, but she will be better in heaven." And so there's a lot of lessons that we've learned from this. There's a lot of hope, and there's a lot of blessings that come from this child. So I don't like to come up here and just say the burdens, but I feel like part of my responsibility is to share the burdens with you. But the burdens are ongoing, as well are the blessings that come with it. But I do think that there is an injustice in this system, and I don't really know what the answer is to it. I think many of you have pointed out that there's many injustices in it. But I feel like the last time I was here, I heard someone come and testify at the end of it, and I don't know that she realized how offensive the comment was, or maybe I'm sensitive and I took it offensive. But I remember her saying she was watching my husband's race because they knew that if he got elected, something like this would be coming down the reins. And you could probably watch the video. I don't know who she is, whoever you are, sorry, but it was offensive. And the only reason I think I found such offense to that is because our situation must be well known enough that there was such a great injustice in what happened to my child and into my family that they could foresee that he would be trying to do something to make it more fair for others. So our goal in being here, we really don't gain anything by this, but our goal is really to try to prevent this from happening to people in the future, and also to advocate for those children who cannot advocate for themselves. And I'm sorry if that's a little bit scattered, but Rebecca next to me kind of distracts me a little bit.
You good.
But do y'all have any questions for me, or no? Okay.
Yes, ma'am. Thank you for your testimonies. Senator Hewitt.
I'm not going to really ask any questions, Susan, other than just to tell you and Ryan again how much I appreciate your testimony and your courage.
Mm-hmm.
And I do think that we're all called to, you know, we're all a product of our experiences, and so I think that, you know, your comment about Ryan, his election, and you know, whatever. I mean, I think that we're all called to offer help in areas based on our experiences, and so, you know, I appreciate you all sharing your story, and I have no problems whatsoever, you know, with bringing the bill forward. I'm not sure that I'm completely on board, to be really honest,
Mm-hmm.
but I respect the fact that you all are advocating for other children, and you know, just deeply respect the both of you.
Thank you.
Thank you, Senator.
Senator Barrow.
And I don't have a question either, Mr. Chairman. I just want to make a comment. You know, as I was listening to you, Susan, I remember when I first saw this book called When God Doesn't Make Sense.
Mm-hmm.
And, you know, when you have certain things that happen in your life, you wonder why.
Mm-hmm.
And we have the right to wonder why. But everything that he does has a reason. And even in this, as I listen to your testimony, you understand that this really is not so much about you guys, but other individuals and families who can benefit from the change that is necessary. And so I want to also echo the comments of Senator Hewitt, and just thank you so much for your testimony. And I do have to apologize. I do have one question.
Mm-hmm.
So the medication that she has to have now, that was never incorporated in the settlement that you guys received. That is now being paid, or you guys have to pay it yourself, or is it through?
It may have been. We don't know because we didn't partake of that. We did settle the future medicals at the time, you know, and we paid our attorney fee out of our future medicals as well as our deductible. So, but we did, thanks to my husband's great new job,
Mhm.
once we meet the deductible, I presume that more of that will be covered.
Yeah, but I mean, yeah, great.
This
yeah,
is
great.
this is why all of a sudden the $16,000 salary reward goes up about $1,000 a month. You know,
Yeah.
for us as individuals. So we
I totally get that.
$12,000 raise right there just happened. Sorry for whoever's paying the insurance for you guys. You just took us on.
Yeah,
So.
but prior to coming to the legislature,
It has been a ongoing battle in terms of we need to make sure that we can never ever leave an insurance plan without another insurance plan in place. And even though we are supposed to make sure that we never do that, we have done that on faith a couple of times and paid out COBRA extensively. Our case settled relatively quickly because it was so clear. If you read that, even one of the physicians, they didn't just agree with the points that were brought to the panel. They added additional points of concern as to points where neglect had happened in the case. But by the time, what was that, just about a year and a half or 2 years into her life? How old was she when we settled?
2.5.
She was only about 2.5 years old, and we were in debt.
yes,
We were borrowing from my parents. We were borrowing from his parents. And it was really just a matter of give us the comfort right now so that we can invest it and we can build on it. And I had this wonderful asset of a husband who I knew would be able to take that and invest more in it. And honestly, that's what he did. He took
Yeah.
it and he spent it wisely, and we've made money from it. And we've probably superseded that by paying for the health care and the standards for what we see fit for our child versus what a PCF would see fit for our child. But that was our goal in accepting it as well, as we wanted to be able to dictate the standard of care for our child. And we just, honestly, it was a leap of faith and a trust of God that we did that. So it may have covered that medication. It may not have. I really can't answer that question, but I do know that it is a hefty bill. But I did pay $0 for my gabapentin yesterday, so our deductible may have already been met. So that's good news for us. But there's a lot.
but for other families,
families
who may experience that, then
Even when we did, so we had health insurance through Ryan's firm and through other things is how we managed to keep our health insurance. But as we had that health insurance, even after we'd met our deductible, I believe that one was still $400 a month. And you have to understand she is on, she's on, the seizure medications, I'll just say it out loud, are Onfi, Trileptal, and I'm going to go brain up here. And there's another seizure medication. Then she's also on Baclofen. She's also on Xanax. And we've also recently started Valium because her muscles are are causing such great pain for damage to her skeletal system that we're trying to find anything to be able to help her relax. So she is on about 4 to 5 different seizure medications and a muscle relaxant, as well as different things that we have to use to regulate her gastrointestinal system.
And you know, I can't imagine what you guys have been through, but I certainly want to applaud you and just thank you for bringing it forth in hopes that, you know, other families don't have to experience this. I mean, you guys seem like you were able to maneuver, and you were able to do various things where it wasn't as onerous, I guess, as it could have been, because, you know, I've heard of stories where individuals actually almost end up homeless, and, you know, just different situations where it really becomes really, really tough to do that, because you're doing everything you can to make sure that your child, you know, is in a better condition, and they're not in pain, and they're not hurting, and all
Well, maybe
those
one day I'll
things.
write my own book so you can read that one on the different ways we've been blessed and carried through this process, because there are too many to count.
Yeah. Well, thank you so much.
Thank you.
Senator Hewitt?
Mr. Chairman, I have some questions at the appropriate time for the fiscal office and maybe the insurance folks, if there's anyone in the room that can answer a few of those kind of questions.
Sure. We have I think the fiscal office is here and available to testify on it. And if you don't have any other questions for the Gattis, what I might do, Senator Gatti and Mrs. Gatti, we might get the PCF and anybody else is here to testify on the bill that come up at this point.
And just you can go ahead and go, honey. The point of clarity, we have these binders that have a lot of information. We put it all on a thumb drive for each member of the committee. It has an index. There's 2 binders, and we also have so that y'all don't have to carry this binder around with
Right.
you. And so that was, so we'd like to
And I think everybody received the jump drive. I think it was distributed to everybody.
Drive somewhere put in the record of the bill.
Okay, sure. And then we'll have you come back up and close in a minute. I guess can the PCF, Schneider and Mr. Schneider and I guess just Mr. Schneider.
Thank you, Senator, for not asking me to carry around that binder and giving it to me on a jump drive. All right, sir, would you just maybe walk us through the fiscal note, please, as a way of starting?
Sure. Matthew Labriere, Legislative Fiscal Office. There's the original note that's online, and you also have the engrossed with proposed amendments. There was also an engrossed version, but the proposed amendments took that one off. If we're going off of without the amendments, I'll walk through the engrossed version of the bill.
Well, just to help me, I need to make sure I'm clear on this. My understanding from Senator Gatti that is, at this point in time, we're looking at the original version of the bill and the original fiscal note.
Yes.
Correct?
Yes, ma'am.
Okay.
We didn't know what the cost would be to the state when the original note was put out. Just that if you pay out $4.5 million more dollars, then state costs would increase. After the bill passed committee, it was amended, and so we put out a revised note with new information that PCF will also testify to as to what their actuary calculated what the rates may increase.
And what was the amendment? Was that where the amendment was added that takes the state out of the equation, or no? That has not been adopted, is
no,
that
ma'am.
right?
The amendment that was adopted in Judiciary A was just to further define the injury and the age, and but taking testimony from PCF, we made some assumptions. If their rates increase like that, then based on the $12.2 million in insurance premiums that risk management charges every year, there would be an increase of about $550,000. And you won't see that note. That was the engrossed note. But since there was a revised note with the proposed amendment, the engrossed note went away.
I'm sorry, I get lost in all the engrossed and re-engrossed terminology still. Okay, so explain to me the number. You've got $12.2 million in premiums that you're estimating. Is that on an annual basis?
That's the 3-year historical average in premiums that have been paid.
Okay, on an annual basis.
Yes,
It's
ma'am.
a 3-year average for an annual number, 12.2.
Yes, ma'am.
Okay, so how did you get to the 500 or 550,000?
Mr. Snyder may also want to comment on that. Their actuary came up with a number of what the increased premium would be. During the testimony, we took that information and just applied it to the state's cost. So just for having the increase, and please correct me if I'm wrong in any of this, just by having the $5 million cap, your premiums would increase by 4.5%. We took that 4.5% and applied it to $12.2 million. From there, we came up with $550,000
Okay.
is what the premium would increase.
Okay, so that's the premium increase of $550,000 if the bill passes with the increased cap. So there's increased premiums assumed with a higher cap.
Correct.
Okay, and we're just talking about, again, the state's
Right, and
share, the burden of the state.
And I don't know if risk management's actuary has calculated that. It does take an actuary to do that. I'm not one, so I can't come up with a number for you.
Okay. And then the other side of this is has to do with the medical malpractice claims that the state would pay out, doesn't it?
But that would be built into the premiums, I believe. So if you pay out the claim, their actuary also came up with a cost for that. For every $5 million you pay out, there's a 3.6% increase. So assuming that happens to the state and we pay out one claim, that's an additional $440,000 that would be tacked on to the premiums.
That would be paid out in terms of claims. What does this mean when you say fiscal year 12 through 14, the average total of all medical malpractice claims paid from fiscal year 12 through 14 was $13.4 million? What does that mean?
That was the amount of total malpractice claims for state hospitals, state clinics that was paid out. I don't have the number of claims that was paid, but it would be the amount the claimant received.
Did those all have to do with brain injuries?
No, ma'am, that was statewide.
Okay, because that question came up earlier.
Right, and when we originally did the note, I think they were trying to look into that, and since the note we didn't know where it was going, I haven't received that information. I can definitely ask for it again.
Okay, so we don't really have a good handle on what the state's exposure could be in terms of medical malpractice claims should this bill pass.
We know the premiums will increase for all state agencies because of this.
Right. But
we can assume.
But we don't know, again, how it will impact us in terms of claims, potential risk of
No, and that would have to be done by risk management actuary to figure that out.
Okay. Okay, thank you. I think I understand the numbers. I wish we had more numbers.
I can put more if you'd like, but we try to keep it simple.
Okay, yes, sir. Do you have a few comments along this line?
Yes, I'm Ken Schnauder. I'm the Executive Director of the Patients Compensation Fund. The numbers he's using on his fiscal note were done by my actuary. We've had the same actuary for 20 years. And what he told you was correct. Just the increase in the limit from the potential for a $5 million claim. Before one's ever paid, rates would have to go up 4.5%. That's with no claims being paid more than are being paid now at $500. And then for every $5 million claim paid, that would be a 3.6% rate increase. And that's across the board of all lines. Because I know I guess the misconception, that may be a bad word, but the misconception is that we're talking about brain damaged children from birth. And that's not the case. You can be brain damaged when you go under anesthesia at 13 to have an appendectomy. There's all kind of varying degrees of brain damage. And the numbers that everybody's been using, most of them are the PCF numbers. We've averaged over the last 20 years 6 brain damaged child claims, of which 3 to 4 were of moderate to severe nature. Senator Johns alluded to the biggest claim the Patients Compensation Fund's ever had was a brain damaged child. We have 14 claims in our 40-year history that we've paid over $5 million on. 14 out of tens of thousands of claims. 9 of those 14 are brain damaged children. And the majority of that damage is medical bills, naturally.
That's all future medicals you're talking about, right?
Correct. And there was a lot of questions about and talk about future medicals that I kind of want to clarify so everybody knows. We operate on the workers' comp fee schedule. That is strictly the amount of money we pay for medical services. We don't operate like a Blue Cross or like workers' comp. We don't dictate what treatment the people get. Their doctors dictate what they get, and we pay. If the treating physician says they need a certain drug, we pay that certain drug. We pay based on the workers' comp fee schedule. By law, the healthcare providers have to accept that, but we don't dictate the medicine that they receive, the treatment they receive. We don't ever dictate that. Granted, as Mr. Gremion alluded, we denied the building a swimming pool for a person that needed aquatherapy. It has to be medically necessary, and we pay all medically necessary needs of children. We do pay the $7.43 an hour custodial care for parents or family members only to take care of their children. Anybody else, if they need round-the-clock nurses, we pay round-the-clock nurses fees. If they need sitters, we pay sitter fees, all subject to workers' comp fee schedule, but we do not dictate the treatment, and we pay based on those rates. Out of state, Senator Gatti, they go to Texas Children's. We don't pay based on workers' comp fee schedule in Texas. That's Texas. This is Louisiana law. We pay an outlier. We make a negotiated price with Texas Children. As long as it's approved medical treatment, we pay it anywhere in the country, and we negotiate a fee. So I just wanted to clarify that. You heard Mr. Click talk about the money that the Patients Compensation Fund has. The hardest thing for most people to understand, and our actuary has to explain it to the board every year, but the claims we're paying today are claims from 5, 10, 15, sometimes 20 years ago. I have a claim open right now that's a 1977 claim that we're still paying medical bills on. That's how long that person's lived that needed future medical care. So collecting the $170 million we do today, that's to pay claims over the next 20 to 30 years. Everybody wants to look at the cash basis. Well, you took in 170, but you only spent 125. Well, we need that 50 to pay for those medical bills that are going to cost 3 times as much in 20 years as they do today. That's the hard thing people have to understand. Yes, the Patients Compensation Fund finally has a surplus. For years, 10 years ago, we were $500 million in the hole, and everybody, the insurance commissioner sued us. He demanded that we have 25 to 30% rate increases every year to make
it
us whole.
actuarially sound. Yeah.
So, the board added 5% rate every year on top of what the actuary said we needed, and that was a cumulative effect over a 10-year period of time. That's what made us whole. That's why we're able to give very large decreases in the past 4 or 5 years, because we finally got to where we needed to be, and claims reduced over that same period of time. So I just kind of wanted to put everybody in perspective as to what's been discussed, and I'll be glad to answer any questions.
Yeah, I've still got a list, Mr. Chairman, if that's
Go
all
ahead.
right. Questions have been kind of accumulating here. So, what type of doctor would, let's see, I don't know how to ask this. So the children that could have brain injuries of the type that we're describing in this bill, what types of doctors are those typically? I mean, are they all OBGYNs or?
That's the more common, and that's the one people think of. Mm-hmm. But it can be an anesthesiologist. It can be, I hate to bring this up, but over the past 2 years, I've had 2 brain damaged children at dentist's office from being over sedated. Emergency rooms, when people come in, there's varying degrees of, an internist, just a family practitioner can cause brain damage to a child. So that's why the actuary figured rates across the board. Naturally, neurosurgeons, orthopedic surgeons, anesthesiologists, OBGYNs, that's the more common that you would think, but there's nothing definitive about who's going to develop this type of claim.
It could be anybody in the process.
Right.
Okay, so what I'm trying to get to is, I think you said earlier that should this bill pass with the higher medical malpractice cap of $5 million, you'd expect an increase of 4.5% on their premiums, right?
That's if it passed. It would be an absolute 4.5% increase, and then the actuary would estimate, based on our past history, because we have no idea going forward, how many claims of this nature we would have, which in the past 20 years we've averaged 4. 1 year we had 12, 1 year we had 1, but the average has been about 4. Well, then you don't know what the dollar amount of those 4 claims may be. 2 of them may be $5 million, 1 may be $500,000 more than, depends on the severity. Right. But for every $5 million in in added claims, that would be 3.6%. So let's just take 2. That would be 7.2% on top of the 4. Okay, so you're at 13% increase would be the absolute minimum the actuary told me he would figure if it passed this year and he needed to do rates. That would be the absolute minimum he would add across the board to all lines. Now, to give you an
Meaning
example,
all doctors that have medical malpractice.
hospitals, every single type of enrollee we have. And,
Okay.
you know, for an OBGYN, that's about a $6,000 a year increase.
That's what I was trying to get to. Okay, that's a $6,000 a year increase in their premiums
Just
to cover,
to
right?
the patient's compensation fund, yes.
Okay. Would you expect I know I'm asking a lot of hypothetical questions here. Would you expect the number of cases to increase potentially just because the cap is raised?
Yeah, I believe for the same reason that Senator Apel and Senator Gatti were discussing. If, you know, it is an expensive process to pursue a claim. If the maximum you think you're going to get is 500 and the attorney takes 200 of it, the maximum you're going to get is 300, less costs, which is going to cost you probably another 100. So you may end up with, like you heard Ms. Frugier said she had $180,000 is what they actually ended up with. Well, if the potential to get 180 jumps to the potential to get several million, yeah, I would venture to say more people would pursue claims.
Looking at it from the perspective of the doctors, do you think that increased caps would have sort of a chilling effect on doctors' willingness to take high-risk cases or to participate in, I don't know, higher-risk procedures in any way?
Yeah, I would think. I mean, most doctors, when you mention this to them, you know, OBGYNs especially, they immediately say, well, I'll just quit delivering babies. You know, that's a knee-jerk reaction, but that's the reaction.
Okay, so last question. I'm still trying to get back to how this affects the state. You're saying now, at a minimum, the increased premiums based on your actuary would be on the order of 13.2%.
Correct.
Right, at a minimum.
Well, on the state side now, the state, I mean, if the cap goes up, that's going to, and they get hit with a $5 million claim, that's going to be $4.5 more million the state would be paying right off the top.
Right.
So the premium dollars would, you know, depending on if they have reinsurance for certain levels of claims, you know, that could be a direct hit to the state's bottom line if they get hit with those claims.
Right. So I understand. I mean, so there's a claims component to our expense, and then there's the premiums, right?
Right.
Okay. So the premiums right now, I'm going to do a little bit of math. I'm not with the fiscal office, so here we go. Our premiums collected during the last 3 years averaged $12.2 million a year, right? So can't I just multiply that times 13.2%, and that would be the increase?
I would agree with that.
Okay. So we're talking about another $1.6 million in premiums that we could expect next fiscal year, correct?
If
this bill passes.
If this bill passed and there were claims made against it.
No, just increased in premiums.
Well,
they're saying they're going to increase their premiums, right? 13.2% at a minimum.
That would be if there were claims against the $5 million. We know based on their actuary, we know 4.5% for sure without a claim being made. If they're assuming two claims, and that gets you up to that would be 11, a little over 11%. If we knew what the state's average number of claims per year.
Okay, so if we had a year with no claims, then we would only have the 4.5% increase in premiums. So it's like when you have a car accident, your premiums go up. So we would wait till we had an incident, write a claim against the state, and then our premiums would go up the following year. Is that kind of how it works?
I would think so. I'm not going to speak for risk management here, but if this bill went into effect and they had a like amount increase, then to start the year would be 4.5%. If anything happened, then obviously that would be recalculated for the next year.
Okay. Okay. And then your exposure is whatever else you would have in terms of claims against you that would be a potential hit to the state.
Correct.
Okay. All right. Thank you. I appreciate that from both of you. Thank you, Mr. Chairman.
And members, not to cut off the discussion or to narrow. I mean, I realize we hear these bills because we're going to discuss them. But for everyone's, I think the author has indicated that this bill in the process will turn into a study resolution, and that the committee is, with that understanding, the committee intends to let it out at least so Senator Gatti can have an opportunity and a venue to voice his concerns about this issue. So just keep that in mind as we proceed. Senator Barrow. No. I'm sorry, Senator Hewitt.
I'm sorry. Would you repeat what you just said? The idea of a resolution is kind of new information for me.
I'm sorry. The Senator Gatti has indicated that his intention is to proceed with the bill, but as a resolution. But that I think that the committee, and I'm not going to speak for the committee, but they were going to give him deference to make his position on the floor with a full audience, and that he would convert it to a study resolution to study this narrowly focused situation in which damages could exceed $500,000. Whether the study committee comes back with $5 million, $1 million, who knows? I don't know, or nothing at all.
Can you do that? You can convert a bill to a resolution, or do you just shelve the bill and start over with a resolution?
Sometimes you take baby steps. Yeah. Right, you get a little bite every year until you at least get your point made. And Senator, I'm not going to speak for the committee, but I think the committee, in my discussions, thought they were going to give Mr. Gatti that opportunity.
Thank you, Mr. Chairman. We don't get all that same conversation on this end of the table. I'm just saying. We're Senator Barrow and I. We're down here. We're working hard. I don't know what you guys are doing on your end of the table, but
I'm sorry that I should have.
There's something going on that end of the table that we didn't hear.
I didn't discuss it. I should have worked the committee better than I did. I apologize.
Thank you, Mr. Chairman.
Okay. Senator Barrow.
When Senator Gatti comes back to the table, I just want to make sure, because when I see this amendment that was being proposed, where I think it took out the state as he's doing the resolution, I want to make sure that component is added in, and I just wanted to make that comment to Senator Gatti as he's doing the resolution. I don't want that to be omitted.
Yeah, I'm sure that the study resolution in its final version will be focused on this particular area of damages, this type of damage, these types of votes in front of the medical. This is what we've discussed, and I'm going to ask Mr. Gatti to come forward before we take any further. But let me get Ms. Maruzak, you ready? Let's finish the opposition, and then in closing, Mr. Gatti, we can talk about what your ultimate goal is at the end of the day and what the committee has informally agreed to do.
Sure. Mr. Chairman, members, first of all, let me assure you this is pretty much the last seat I want to be sitting in right now. But also, let me say to Mrs. Gatti, I am the one that said that in the other committee. And the reason I said that about this legislation coming was because then Senator-elect Gatti had told that to my colleague when they had lunch, because they'd gone to law school together, and they had lunch together before he got elected, and he told him the bill was coming. So that's why I said that. And with all due respect to Senator Gatti and his family, we just wanted to say on behalf of the Medical Society that we know the system's not perfect, and the study, as you mentioned, is we're happy to be at the table for that discussion. We just feel in general terms this kind of legislation to talk about one specific kind of instance, one specific kind of injury probably isn't the best way to deal with the whole system, and that looking at the whole system is probably the best avenue for all of us on both sides of the issue, and we look forward to moving forward with that. So thank you very much.
Senator Bishop.
No.
You still have a question? Okay, no questions. So we don't have any further questions. Senator Gatti, we've talked before, and I've talked to everybody on the committee except Senator Barrow and Senator Hewitt, which is pretty obvious.
Other than that.
Other than that faux pas. Senator Gatti, I mean, you made some great points. I can't help but yeah. So, look, I got 3 kids of my own, so I cannot help but admire the kind of devotion that you have. I would believe that in malpractice cases in this narrowly focused area, and possibly as Ms. Marusak has pointed out, maybe the whole system, I guess, needs to look at. It's certainly not perfect. I practice, like I said, I think I've had 4 cases in front of the medical review panel. I've been involved with Mr. Schneider on some other cases in the past. It's not a perfect system. We don't change it, these kind of major changes, we don't typically make that overnight with one bill in one session, because the implications for the whole medical system as a whole or can be seriously affected. But I think the committee recognizes that we probably need to look at these things, and maybe your situation, as unfortunate it is might be fortunate for others, in that in the future changes can be made that would make the system better, and as your wife pointed out, fairer. So with that, I'll let you. So I think the committee, once it will let you out so that you can have an opportunity on the floor to make some of the same points you made today, and then work with the groups that are in the back and those that are out not here today to come up with some solutions.
Thank you, Mr. Chairman, members of this committee. Based on the all the facts that we've derived out of this bill and just the documents that we've put together for y'all to review, this is not something we can turn on a dime and take care of this year based on just the cost to the system. But what we did today is we did what the Supreme Court asked us to do. The Supreme Court said that we have the obligation as a legislature to do a balancing test between the harms and losses that families suffer and then the rights and obligations of our hospitals and doctors. So I appreciate your time today, and I'll just leave you with this. The most common thing Susan and I get told, whether we're at church, on a mission trip, or wherever we are, even at Walmart, people say, oh, God gives people these kind of kids for a reason, or they give these kids to a special family for a special reason. And there's been a lot of reasons we found out that God gave us Rebecca. This might be one of them. And so I appreciate y'all's attention today. I know you got so many bigger fish to fry in our budget process, and I appreciate you so much for your questions, for the time you've shared with me and my family today, and it means a lot to me. But based on everything we've talked about, I feel like this is such a big change to the system, maybe not as it may be too tailored and too specific. And I will agree to meet with all sides and put together any type of committee or commission to walk through this to make sure that this doesn't happen to any more babies. And if it does, their families don't have to file bankruptcy.
Well, thank you for your testimony, Senator Gatti. Like I said, I will speak on behalf of the committee. I think all of us admire the way you've handled that situation. I know that I don't know if I would have had the wherewithal to do what you're doing today. I hope that I could have, or that I would if the occasion ever arises.
Well, I want to share this with any families that are listening. I mean, we've taught our 2 oldest kids, Senator Barrow, what you hit on is I've had to sit down with my kids and tell them the majority of your life happens after you pass away. Don't try to spread all this pain and suffering with Rebecca over the 80 or 100 years you have with her here. Said 500 years from now, you will have spent more time with her in heaven with a perfect body than you could ever spend with her here on earth. And that's the good news of the gospel. So in teaching that to families, whether it's a Sunday school class or at our church who have a child that is like this, or even a parent with Alzheimer's, it's important that we know as Americans that our country believes in a certain spiritual being that we are. We're not a body that happens to have a soul. We're a soul that has a body, happens to have a body. So I would just want to share that comforting thought. That's how we make it. All right? That's how we make it through the day. All right? So, but I appreciate your comments, appreciate your kind words, and I thank you for your time.
Okay. And Senator Gatti, so we'll let this bill out, and then we'll hear from you on the floor about your final draft of a resolution. So
Correct.
With
Thank
that,
you, Mr. Chairman.
I'd move that the bill be reported out favorably. Without objection, so ordered.